May I please, Lordship? Lordship, I beg to mention item number 7, Lordship. Lordship, validity matter may be taken up on 2nd of March, Lordship.
Why?
Lordship, we have been advised to file another one separate writ petition, Lordship, and we have already filed. And that separate writ petition have been listed on 2nd of March, Lordship. So matter may be taken up
This
together,
matter
Lordship.
along with, what's the writ
A.
petition
Brahma,
number?
Lordship. A. Brahma, Lordship.
Writ petition number.
The other one.
You
Lordship,
say that it is listed on 2nd of March, therefore there
Lordship,
is a
the
number.
the other one is not been numbered yet, Lordship.
Then how do you know it is listed on
Lordship,
2nd of March?
it will be numbered today, Lordship.
How do you know?
Mention it.
Lordship, we have I have already
Counsel
mentioned here.
appearing on behalf of the petitioner seeks for an accommodation. This is the matter on next Thursday, 5th.
Lordship, 2nd of March, Lordship.
5th. These are High Court matters. High Court matters only on Thursday.
High Court. Obliged, Lordship.
So Nair, I'll take up this matter around 3 o'clock, 3:30. Okay?
Mine.
This will take some time, so
Mine.
you will have it.
Mine.
Your Lordship, my senior is in court number 1.
We have also filed and replied also yesterday. Yesterday, we have also filed reply also.
I just
I
come
think
on.
that is that one. Or Lordship, senior counsel, he is trying to log in, Lordship, I think.
For the time being. None is appeared on behalf of the petitioner on call. Mr. S.S. Roy appears on behalf of the the learned CGC appears on behalf of the respondent. It is mentioned, this court have duly taken note of the order dated 12/2/2026 passed by the learned coordinate bench of this court, wherein the instructions so placed by Mr. S.S. Roy, the learned CGC, was taken into account. It is relevant to take note of that as per the instructions of the respondents so placed, there was no contract entered into by the respondents with the petitioner. Further to that, it is also mentioned that the allegation that amount of rupees 3 lakhs was transferred to the petitioner's account, petitioner brother's account, is also false, taking into account that the unit, that no amount as such was ever transferred. This court also takes note of that in view of the said instructions being placed, time was granted to the petitioner to obtain instructions. However, the petitioner is not present. Taking into account the above, it therefore appears that the instant writ petition, in the instant writ petition, there are serious disputed questions of facts as to whether the petitioner at all was granted any contract. And further to that, as to whether the respondents have at all paid rupees 3 lakhs to the petitioner's brother. So considering the above, it is the opinion of this court that this is not, the present writ petition is not a fit case to be entertained in terms with entertained under Article 2 to 6 of the Constitution. Accordingly, the instant writ petitions therefore stands dismissed. The dismissal of the instant writ petition, however, shall not preclude the petitioner to avail remedies before the competent civil court, if otherwise permissible under law.
Your Lordship, matter relates to impugn action of the respondent authority in non-resettling the land in the name of the original pattadar, settlement of which has been annulled due on view of non-payment of land revenue laws. Lordship, no affidavit has been filed.
Lordship, with due respect, we have been recently impleaded, Your Lordship, filed order dated 1/9, and thereafter, Your Lordship, on the 29th of January, we have received the copy. So what I'm praying for is that Your Lordship will take it up next week, Your Lordship. I will have the instruction. We've only received the copy on 29/1/26, Your Lordship, of the writ petition.
This court duly takes note of the order dated 29/1/2026, whereby the counsel of the petitioner was directed to furnish a copy of the writ petition to the Standing Council of the BTC. Taking into account the Mr. So-and-so appearing on behalf of the BTC submits that some more time is required to obtain the necessary instructions in that regard and to file an affidavit. He, however, submits that positively the affidavit would be filed within a week's time.
Lordship, we will do it.
Accordingly, list the matter on 23rd of March 2026. Affidavit be filed on or before 18th of March 2026. Liberty given to the petitioner to file reply thereagainst.
Public.
May it please your lordship, may it please your lordship. I apologize for I could not hold the brief
You are appearing.
for Mr. D. Deka.
Madam, have
Lordship.
you forgotten to wear the band?
Sorry. I apologize, your lordship. Your lordship, I pray for pass over for time being.
What is the matter, Mr. Roy?
My lord, here the petitioner was a contractor for engaging security services. My lord is claiming the relieving charges for in addition to the, my lord, daily wages. Lordship, earlier occasion also dealt with this similar matter.
Huh?
Earlier occasion also Lordship and petitioner had to withdraw. He's claiming, my lord, because on for holidays, the workers working as security service are entitled for 1 day off, my lord. And that off day is calculated towards the daily wage. That is that's the thing.
Maybe pass over for some time.
Senior is there.
He's around, like he's coming. Much obliged.
In this matter, government was supposed to file affidavit. On the last occasion, it was sent for vetting, I think.
Affidavit is come, lots of, there is so many, vernacular process we have given, it for cancellation, this. What? Let us see first his case, what is his case?
Otherwise, matter is,
Your
my lord,
case.
yes, a plot of land was donated to the army by the predecessor of the petitioner. But for establishment of transit camp at Hosea. But when they subsequently, my lord, occupied the land and made fencing, other plot of land of the petitioners have been also occupied illegally by the army,
When?
my lord. In the year 2018-19, during that period.
Huh?
18-19, during that period, fencing was made, my lord. So, my lord, an application was filed before the circle officer for demarcating the matter, and accordingly, kindly come to page number 10, my lord. Annexure A,
Yes, then,
11 is the vernacular,
then,
and notice was issued to the transit camp and other persons also for demarcation. But thereafter, my lord, circle officer did nothing, my lord. Only said that this is my lord, as because fencing are there, occupied by army, we cannot
yes,
measure.
Mr. Hendrik,
So in your
when you have
I-
issued a notice for demarcation,
Lordship,
you have to carry out,
Lordship,
and they should aid it, help in,
only that direction is needed, my lord.
that's all.
Lordship can be dispersed. Yes, ma'am.
They will also aid. That's all.
Because they have also filed one.
Heard Mr. D.K. Nath, the learned counsel, appearing on behalf of the petitioner. Mr. J. Hendrik appears on behalf of the respondent.
Respondent about
first.
3 and 4, Lordship.
3 and 4. Mr. So appears on behalf of respondent number 1 and 2. It is the case of the petitioners that the petitioners are owners of a plot of land at measuring 1 bigha 2 kata 3 lechas at Dag number 06, covered by Khiraj Miyadi Patta number 05 at village Khongor Gaon under Lamding Moza in the district of Hosai, Assam. It is contended by the petitioners that around 30-35 years back, a plot of land at measuring 1 kata 10 lechas adjacent to the plot of land mentioned above, adjacent to the land of the petitioner. What is this? What is this language used? The word is 1 kata 10 lechas of that land. Then what right you have?
This Dag number, my lord.
Huh?
Yes. Now they are occupying.
So you should therefore say that it should have been 30-35 years you gave 1 kata 10 lechas of land.
30-35 years back, my lord.
Understood?
Yes,
You
yes.
gave 1 kata 10 lechas of land
Yes.
from that plot of land which belongs to you.
Yes.
That should be the language. It is something
My
different.
lord.
When you are saying adjacent to that land means it is some other plot of land,
That is-
isn't it? What do you mean by that? Isn't it?
that is correct, my lord.
it is also further case, it is further contended that 35 years back, a plot of land at measuring 1 katha 10 lechas from the land belonging to the petitioner. Page? From the land belonging to the petitioners. Was donated
Well, that is correct. That is
by the predecessor in interest of the petitioner. To the respondent number 2 for construction of the army transit camp at Khongargaon bracket Bighan Pali, Lamding. It is the case of the petitioner that the respondents number 1 and 2 thereupon trespass into the lands of the petitioner, the remaining land of the petitioner. Respondent number 2 thereupon trespass into the land of the petitioner, for which the petitioner submitted an application before the respondent number 4 for carrying out a demarcation. Accordingly, a notice dated 6/5/2021 was issued by the Circle Officer Lonka Revenue Circle to the Army authorities for demarcation of the land fixing 12/5/2021. However, no steps thereupon was taken on the ground that the respondent number 2 have not permitted to carry out any demarcation. The record reveals that this court had issued notice as far back as on 25/2022. The respondent numbers 1 and 2 had filed an affidavit in opposition.
Yes.
Wherein it is mentioned that the land held by the respondent number 2 at Lamding is AI defense land measuring 0.66 acres, that is equivalent to 1 bigha. It is also mentioned that as per the extract from the military land register, the dag number of the land is dag number 2, bracket part patta number 1 of village Kongor, Gaon Moja, Kongorgaon, Moja, Lamding district, Nagaon.
At that time, Nagaon, now Hosai.
Bracket presently Hosai. The same have been also verified in the report on survey of the defense land at the Lamding transit camp under the station headquarters MISA held on December 2013. Apart from that, a fresh survey was conducted in the month of December 2021, but the report is awaited. In addition to that, it is also mentioned that the said land at measuring 0.66 acres was requisitioned with effect from 31/7/1966 under the authority of HQ 41 sub-area letter number 0244/40/Q343W dated 17/1/1966. Subsequently, the same was acquired under the, what is this RAIF? Act 1952 with effect from 4/3/1970 by the authority of Government of India Ministry of Defence bracket Army letter number 1/2 Assam ACQ team 362-S/5D land dated 30/6/1969 and the DC Nagaon letter dated so and so. Number NRQ 63/66/57 dated 19/2/1970. Possession of the land was also taken as far back as on 31/7/66, and the compensation for the amount was rupees 4,982.50. From a perusal of the pleadings, as well as the documents so enclosed therewith,
Immovable property.
shows that while the petitioner claims ownership of a plot of land at measuring 1 bigha 2 kata 3 lechas at dark number 06, covered by KP Patta number 05 at village Kongar Gaon under Lamding Moja. But there is no documents enclosed showing the petitioner's ownership of such lands. On the other hand, the respondents herein have categorically placed the necessary documents on the basis of which the respondent claims the ownership over the land measuring 0.66 acres, which is equivalent to 1 bigha. Be that as it may, it is pertinent to take note of that the respondent be that as it may. Mr. Nath, we are dismissing it. Unhelped. Because you have not enclosed anything. Where's your ownership document?
Paragraph number 2.
What paragraph number 2?
Jamabandi has been annexed.
Where is the Jamabandi? Show me. Where is the Jamabandi? Huh?
Notice is
Annexure 2 is what? It is an application filed by you.
application.
Where is the Jamabandi? Taking into account that the petitioner have not placed any document to show their ownership over the land,
I have the Jamabandi copy with me, my lord.
the question therefore does not arise for this court to pass any direction upon the respondent number 4 to carry out any demarcation by issuing a writ. Under such circumstances, this court is therefore not inclined to entertain the under such circumstances, this court does not find any merit in the instant writ petition, for which the writ petition stands dismissed.
My lord, may I pray?
Be that as it may, it is observed that the dismissal of the instant writ petition shall not prejudice or preclude the petitioner to file a suit before the competent court of civil jurisdiction seeking recovery of possession, subject to the same being permissible under law.
Lordship, RA IP means Lordship Requisition and Acquisition Immovable Property Act 1952.
Mr. Nath, you have to be more better with filing this type of petition. What you have stated is also wrong. Not how you do it. Anyways, where is Mr. Betala?
Okay.
May I please, your lordships?
What is you?
I really beg to stand here.
Are you Mr. Soor? Are you in a school? I have seen you in 3 matters appearing before me, and every time you raise your hand. What is this?
I seek apology
Kindly
for-
change your attitude in appearing before the court. And instead of raising your hand, it seems that this court only allows those person who raises his hand.
No, your lordship, it is not that precedent.
This is the third occasion it has happened. Anyways, yes, Mr. Betala, what is your case?
Lordship, I am most humbly pray to contend for item number 3, your lordship. I am on behalf of AK Purakasta, sir. May I please, your lordship?
No, that is dismissed.
Your lordship, actually, we wanted to.
Oh, you are asking this court to pass on after dismissal?
No, I'm just praying and begging, your lordship.
No, don't beg. Nothing happens. Go to the civil court. I'm not dismissed the entire thing. You go
My
to the
presence may be recorded, your lordship.
next. Why?
Please, your lordship.
No.
It was for AK Purakasta, sir, and he's due to personal difficulties of medical emergency, he asked me, and due to my difficulty, I owe it, your lordship. I owe the entire issue at my own.
Fantastic. Then we dismiss it with cost.
Presence of the.
No, I'll dismiss it with cost
No, Your
for
Lordship.
misleading and abusing the process of the court.
No, your lordship.
You were asked to obtain instructions. What was the case out here? Look here. I was given a contract of rupees 5,40,000, of which my 3 lakh was paid, and this 3 lakh was paid into my brother's account because I didn't have an account there. Now, rupees 2,40,000 is payable, which they have not paid, for which you have filed a writ petition. The instruction which was obtained and placed before this court on 12/2/2026 is that, look here, there was never any contract. No payment of rupees 3 lakhs was paid to any of his brothers from that unit. And therefore, it is absolutely a fake claim. This court asked you to obtain instructions on 12/2/2026 as to whether there is anything. You don't have any instructions. And under such circumstances, I dismissed it. Now the question is, the moment I saw your appearance, the manner in which I conduct my matters is I have to impose a cost for filing a false claim before the court. But without your appearance, I said, okay, let him go before the civil court. Which one do you want?
Your lordship. Much obliged.
And I'm to bhai dibo. Nothing has been brought.
Much obliged.
Yes.
Yeah, pursuant to your lordship's order on 11/12/25, we filed this representation. And
Yeah, we are looking into this.
Hello?
We are looking into
Yes.
this. These rules are being reframed.
Yes.
And see, the rules are in a very sloppy state of affairs. So it will take some time. We have asked them to give us a fresh draft on the various representations. And once it happens, then I think it has to be looked into. In fact, it will be an total overhauling of the rules. It is not that, although the court says that specifying the appointment conditions in lieu of so and so, to compile a comprehensive fresh set of rules. So we are overhauling the entire rules. So
Will
we'll
take
look
some
into
time.
that representation. We'll keep this matter for some time.
Yes.
Or should we close it, taking into account that that will be considered liberty given to you to come again? Because it makes no sense keeping this
Yes, sir,
matter
that's
pending.
Madam. Yes.
Taking into account that they have already submitted the representation
And
and it is before the committee. And if these aggrieved later on again, he
Liberty.
can come.
They can come, yes. In fact, the rules are the need of the hour, my lord. The change of the rules, my lord. It's a.
that is the reason we are before this court.
No, it happened because of some judgments passed by me, which resulted in these rules coming up.
No, that's.
Because
true,
this
my
is otherwise it becomes very difficult. Because there are many aspects on the rules. One is the case of what is the qualification required under section 7(3)(a) for the purpose of that the private secretary to the chief justice.
Yes.
That is one aspect, because that is also being put up as to whether he should be a law graduate or
lord.
not.
Because of the subsequent amendments, there were so many contradictions.
Now,
that we-
another case is as regards the court masters. The court masters have been brought under 7.5. They are said to be. Only one provision is there that the court masters can become the AOJ. But there is no corresponding provision in the rules that from the SJA one can become the AOJ.
Yes.
But it is done just on the basis of some precedents going on. But there is nothing in the rules. No notifications also to that effect in the
In fact, there is
rules.
no sink in the rule. If
So
we go
therefore,
through the rule, there
we
is
are
no
looking
seriatim.
into, we are looking into it. So
Correct.
that not only that, another thing, the most interesting part, Mr. Das, is this. An assistant librarian can become an assistant registrar, but a librarian cannot. This is the state of affairs in the rules. So all these things needs to be made. Okay. It is seen the great heard Mr. D. Das, the learned counsel, appearing on behalf of the petitioner, and Mr. So-and-so, who appears on behalf of the Gauhati High Court. The petitioners herein are working as stenographers, grade 1. Grade 1, huh?
Grade 1 special class.
Grade 1.
Grade 1 lotships.
Stenographers, grade 1. And are aggrieved by the limited chances of their promotion to the post of assistant registrar. It has been brought to the notice of this court that a representation has already been submitted in that regard before the committee constituted
Have given this
to
notification.
amend the Gauhati High Court bracket appointment, conditions of service and conduct bracket close rules to 1967. The said representation is presently being considered by the state committee. And the state committee have further appointed another subcommittee to compile a comprehensive fresh set of rules by taking into account the various representations submitted. Taking into account that presently the committee as well as the subcommittee, the aforesaid committee as well as the subcommittee, are looking into the grievance of the petitioner. Mr. H. Petala, Mr. D. Das, the learned counsel appearing on behalf of the petitioner, submits that the petitioner would not like to pursue the instant writ petition, however, with a liberty to again approach the court if the grievances remains unredressed. Taking into account the above, the instant writ petition accordingly stands closed. It is observed that in the circumstance, the petitioner's grievances remains unredressed. In the proposed new set of rules to be new set of service rules to be framed, the petitioner would be at liberty to approach this court.
That representation we had, and that is, Lordship, the representation which we filed in terms of this new committee is 12 February 2025.
I had submitted 12 February 2026.
26, Lordship.
26.
In fact, what has happened, I have been keeping track of your representation. Then your representation has been given separately.
Separately, Lordships.
Then
than
the
that,
association has also given another representation. Then I think the court masters have also given another representation. All these things, representation. Then there is a representation from the librarian from Mizoram who have given.
Yes, Lordship. Outline
All
in
these
case
things
of the-
are being looked into. And yeah, so we'll look into it, don't worry.
Lordship. Only issue was that the stagnation is there in that post only that part. Basically, that
stagnation
the
is
date of
everywhere.
Fixation.
Now this stagnation is everywhere.
I'm so glad.
Highly pleased.
Please, your lordship. My lord, this is the issue of the second wife. On a previous occasion, your lordship had directed me to verify how could she be treated as the wife. I have proof. Her
Married in
petitioner's own
1970 at North Lakhimpur to her husband. And Anu Borgohai is there.
Anu Borgohai has died immediately within a few months of death of the deceased employee.
Okay. So now therefore you are the only wife
I'm the only one left.
and you should be getting it.
I should be getting it.
And the others may have at best a claim, which is different.
There are no unmarried daughters dependent on.
And the sons have also grown. What are the ages of the son?
Attain majority, 20.
Then also they don't get it. Why they are not being paid?
Lordship, kindly come to Lordship. Paragraph, para 4 and para 5 Lordship.
Of?
Which petition?
Yes, tell me.
1, 2.
After which the aforesaid deceased second wife applied for family putting forth her claim as the sole wife here. In order to achieve this end, she has obtained an NOC from the petitioner in 2000, which she stated was to be used for other purposes, including the transfer of vehicle area.
Anu Borgohai's name was in the nomination. Lordship, kindly come to para
No,
8.
my question is, did you take into account the NOC given by the petitioner in granting the family pension to Anu Borgohai?
His own statement, her own statement, paragraph 8.
Understood.
She-
My
she
question
said
is
she
this.
document to prove that she is a married wife of.
I have. That is what I brought.
Paragraph 8 material.
I have the document.
Eight.
I have obtained the document, man.
If you have taken the issue of
I will file it by way of an affidavit.
Then so but the same also completely as there was nothing on record to indicate the petitioner was the spouse and nominee as the prevailing couple. The pandemic. Not take the petition.
Nothing on record to indicate.
What is there?
That is my pension book. I am also a retired government servant. My pension book reflects the name of the husband, the deceased employee here. And the Gaubura certificate that I am the first wife. These I seek to bring on record.
Now tell me, no, my question therefore again remains. Did you take into account the NOC issued by the petitioner?
We simply acted because of Anu Borgohai's name was mentioned.
No, so NOC is not a part of whatever was taken. Let's see what is your stand. Why you have rejected it?
There is no question.
Then what have you done?
We simply, if you get to approach it. simply
No
to
affidavit. No
represent-
affidavit has been filed also. No
Hmm?
affidavit, no letter rejecting my representation, nothing. The district judge establishment.
No representation to us.
That was forwarded also to the pension department. Accounting.
Have you inquired about this next of kin certificate?
He have to come with all those papers to us.
No, this next of kin certificate is not given to you when he is making the claim. 100%.
I've given the representation.
Receipt, Lordship.
This has been forwarded.
Why it has not been received by them? We have forwarded, then. I'll place it. Okay.
Let him give the data, I will take instruction.
You have this copy of the writ petition or no? You have read only the petition, not the enclosures.
Since a name of nominations.
Nomination is a different thing. Nomination, a lot of husband always love the second wife and give it.
Statement that says.
They don't. They are not fond of the first wife. That is why they marry the second wife, and then give it. Problem arises, and because of that, are you going to give it? You don't give it. If there is a first wife out there, no, tell me that day another case of Mr. A. Ganguly. You have not given him, although that is the second wife. You have not given him the second wife, taking into account the first wife have laid a claim. The mother had laid a claim, isn't it? So there you have a problem.
In case,
Although nomination is there of the second wife.
in nomination lordship, we have to act lordship.
Only one thing, my lord.
Chakravarti, the accountant general office is again another big.
Only one thing, my lord. She is the first wife.
Yes.
Marriage was solemnized in 1970. My lord, till 2024, there is no record regarding her marriage with the deceased husband.
No marriage certificate at that point in time.
My lord, not only
What are the birth certificates of these people? Your daughters?
The birth dates of my daughters are 30. One of them is 30.
Birth certificate?
30. I have given in the details as given in the
No, about the birth certificate of your daughters.
birth certificates, my lord. I have not annexed. I have given the name.
No, names are okay.
I can produce the birth
Mr.
certificate.
N. Borwa, when you are appearing for the respondents, you
Yes.
would be putting that very question tomorrow. But the question is, you are therefore to show that these are the daughters.
I will replace their respective identity certificates with the name of the father as well. They are 47 years old, 43 years old. So they will have the documents. I'll place it by way of an additional evidence.
And you got married?
They
No.
got married 47, that was 70s.
So they will have that birth certificate. They will have passport or Aadhaar card.
Any document with reflecting the name of the father.
The father.
Father, yes.
So then also one can ascertain, because the other sons have been, the ages are 29, 27 or something. Because at that point of time, there was no registration required. You must have married out there, married somewhere.
Married and Lakhimpur and their state separate.
Lakhimpur doesn't have a marriage register there. The learned counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit, bringing on record further documents to show that there was that late Rupeswar Borgohain, na,
Yes.
yes, ma'am.
was the husband of the petitioner prior to the marriage of late Rupeswar Borgohain with
Onu Borgohain.
late Onu Borgohain in the year 2000,
Well, even there.
in the year 1998.
1998.
Full stop. 3 weeks' time is granted in that regard. List this matter again on 2nd of April 2026.
Obliged.
Please, Your Lordship.
Yes, what is this?
My lord, this matter relates to, my lord, the land acquisition by way of, my lord, negotiable settlement by the district level land purchase committee, my lord. It is in pursuance of, my lord, one gazette notification that is published in 7/3/2022. In pursuance of a cabinet decision, the provision is made, my lord.
What is the respondent number 4's affidavit?
Yes, but they have filed, my lord, the affidavit. But they're now trying to, my lord, in spite of the direct negotiable settlement and direct purchase in between the agreement between the parties, agreed the amount. Now they are saying that their land value is reduced, so they are not entitled. I am not entitled to that amount, my lord.
Return the land. You don't have the money.
Our paragraph 7, Lordship, that is the case. It is a direct purchase, Lordship, negotiated settlement.
If the both parties agreed and sign the document, how they can now deviate from the original agreement?
2 lakhs, 2 crores, 73 lakhs.
X, yes, Lordship.
That was the agreed amount.
Not agreed amount.
This is when
That is the calculated amount as per the,
agreed amount is three crore
had it
97
been
lakhs.
acquired, had it been acquired,
Have you acquired?
no.
It is
No, it's acquired, but through direct purchase.
purchased by the.
So negotiated settlement, Lordship, by that, Lordship, amount is more than this amount, Lordship. If that direct purchase fails, Lordship, in that case, we will have to acquire it, Lordship, by way of that act, Lordship. In that case, I think this would have been the amount. But it's direct purchase. I must admit, Lordship.
So if it is the direct purchase, then you have to pay whatever it is.
Yes, as agreed upon the amount.
But this is a scheme made under section 46.
Yes.
This is,
The right
yes,
to
but
pay
it is by way of a
compensation.
cabinet decision, my lord. That is the cabinet decision is there.
Cabinet decision also says about section
Yes,
46.
yes.
Right to pay compensation. Right to pay compensation.
This land is acquired at Assam, under Assam Mala, Lordship.
That is why Assam Mala is based upon section 46.
Yes, yes. এইখন আছে নেকি হে fair compensation?
এখন বলা কথা আছে।
Under that? 56 আছে না? Direct purchase, negotiable.
So we set aside this
Lordship.
as there is no acquisition. Because the very mandate by which Assam Mala scheme says that it has to be agreed at that particular price.
Lordship.
And if it is not agreed to, then they will resort to actually.
Yes.
So we set aside and giving you the liberty to initiate action, and they will be entitled to only during this period the requisition amount, which has to be done as per the Assam Urban Area Rent Control Act. Assam, whatever may be, in that manner it has to be done. Because you see, it is being done under section 46, one of the so and so government has adopted steps 1. shall finalize the minimum extent of land to so and so step. General notice shall be issued by the district so and so, inviting the attention of the heir regarding purchase. The owner who may agree to sell the land may identify a list may be prepared after ascertaining the actual owner. The list shall be published inviting so and so. The valuation of the land as if any thereon, the particulars of land, name of the owner shall be prepared. Shall be 25% higher on the compensation calculated as per the provisions of section 26 to 30. With the multiplier of the market rate of the land defined to Al Assam land acquisition notification. On completion of the staggered period in 3 years, so and so amount. Agreement reached in the negotiation shall be recorded as an agreement to Form B and Form C. Done.
It is done.
For the land and for interested persons other than landowners and if any, respectively. An undertaking may be signed by the landowner declaring that they will not claim for payment of higher compensation in any court or any other form and shall abide by the sale agreement finalized by the DLC. The landowner and the other interested have to provide the electronic transfer details. Collector may requisition the necessary funds for the required. The so and so shall
That
make
is
an
annexed.
award according to the terms of this agreement. Now the award is made, has been made.
My lord, they have, my lord, accepted this amount, but they are not paying the amount, my lord.
No, have they passed an award?
Award is not passed.
Award not passed.
So then there is no acquisition. The land has not yet been acquisition.
It is signed between the parties, my lord, the land acquisition authority and the, my lord, this person concerned, my lord. And construction work has been completed. It has been, road is already, my land is already completed, my lord.
So therefore, 4.17. In the event of any owner refusing to sell the land or any of the owners have objected or not interested with the direct purchase through negotiation,
Lordship.
the respective land may be acquired through the year. The cost of direct purchase and the process of direct shall be done by the requisitioning authority. So as you have, you are not now agreeable to the agreement which have been entered into. You have to return the land. There is no acquisition. Has your land been taken?
It is taken, work has been completed, road is completed, vehicle is running over the road, my lord. Total,
When was the land taken?
my lord, that was taken on, my lord, this is NOC that was issued on 5/3/2023, my lord. And when the agreement was signed later on. Gazette notification was later on.
Huh?
First, my lord, land was taken, then, my lord, gazette notification, then land was acquired. And
Land taken how?
but there is a gazette notification for this direct purchase agreement. Lots of lands were there under falls on the same project. Our lands, my lord, that is 49.
No, the land has to be acquired under what provision?
But there is a gazette notification was there, my lord.
Where?
This is my annexer.
This is it, 28th of January 2021.
My lord, the first gazette, my lord, this is regarding annexer 1, my lord.
Page
It is page number 24.
20.
24.
20. This is 7th of March 2022.
Then, my lord, the paper publication was there.
Oh, I am looking into 2021. This is 22.
The committee was, my lord, constituted.
Where? Page?
It is page 25, my lord.
Page?
25. Who are the member?
Deputy Commissioner so-and-so, concerned Iman and the representative general notice. How can a possession be taken prior to that?
My lord, they issued a, my lord, contractor was appointed. Contractor issued a letter to me, my lord, and then requested to my lord, cooperate with the construction. So in the interest of the public, we have, my lord, given the consent. And after that construction was going on, then paper publication was published. And on the basis of that, our land, 12 numbers of dags falls under the total 49 bigha, 8 bighas, 8 kata lands has been, they have taken.
And where is the agreement entered?
Yes, my lord. The agreement, my lord, that if lordship will come. After that, my lord, annexer.
Where is the agreement?
Yes, my lord.
47,
Agreement, my lord, 47, it is started.
48,
Huh?
47.
47, it is started, my lord.
Where's the agreement?
This is the, my lord.
Nine.
It doesn't have any date, say, nothing.
They have not mentioned, they have only, my lord, put our signature and amount was mentioned and this area of the land is mentioned. They kept that, they said that this will be, later on that will be filled up. Only signature were obtained. That copy was available with us.
And what is that, page 49?
49 is again another land, my lord. Total
Different land.
12 numbers of agreement was executed.
One is Dag 18, Dag 19,
All dogs were separately.
and another one.
Yes, my lord. Total 12 numbers.
So, you are.
All 10 less also 20.
Still 69 is
Now,
continued.
what is this page, Annexure 6?
My lord.
Annexure 6?
And that's a my lord, Jirat value that is.
Huh?
Jirat value. Jirat. The tea
Okay.
bush and my lord, other trees.
Okay, then
That is 1 crore something that was my lord assess.
now they are trying to pay you this amount.
The land value is reducing, but Jirat value they agree. They are not disputing the Jirat value. But they said I am not entitled to the 3 crore that amount is I am not entitled 2 crore something they are trying to pay money.
But is it 25% above the market value?
Yes, my lord.
Because you see, you also one has to take note of that if the Jirat value or the value of the land which is being taken along with the Jirat has to be computed in terms of 26 to 30,
Yes, my lord.
which will include also the multiplication factor. And above that, there is an amount of 25%. That is the mandate of this.
My lord, there is a my lord, the facts was
It
there.
cannot go beyond that.
My lord, there was a fact, my lord. At the time of my land was acquired, the land value was higher. So after that, my lord, what they did, they reduced the land value. This is the fact. On the basis of now reducing land value, they are trying to say that I am entitled to this amount. But at the time of relevancy of that time, land value was higher as per the my lord.
No, the land value has to be taken as on the date on which
Yes.
it is, because
Yes.
this is done under that.
Yes.
Therefore, section 23(1) categorically says.
Yes, my lord.
26(1) categorically says it is on 26(1), 1(2) or something. It says categorically that it shall be on the date on which the notification is issued under section 11.
Yes.
So it has to be taken on that value. So if that is so, then it has to be on that value, nothing else.
My lord, they are trying to say that no, it is land value has come down, so you are not entitled. This is the facts, my lord.
Well,
So they are not agreeing.
this is a fact. Can this court take judicial notice?
My lord, they are not hesitating on these things, my lord. Whatever, my lord, I came to know why they are reducing the land value. This is the reason, my lord. They are not come with that facts, but I know these things.
Now, my question is therefore, as per the adjudication being carried out, because you don't have a right of appeal
Yes,
if you
it's a
agree to
final, my lord.
this.
Yes,
This final.
yes, my lord.
But the fact that you are saying that you are not therefore going for negotiated.
Yes, my lord.
Now, you see, Mr. Sharma, the problem which is, what is the difference in the amount?
About 1
Because
crore
now what happens? Have you looked into taking into calculation otherwise? Because now what happens, if you go for an acquisition, would it be in your interest? Because this court has to say that this acquisition never happened because you are not now agreeable to the agreement. And then the amount would become much higher, taking into account that the value has to be taken as of now.
lordship.
And this must have happened long time back.
It is 23, my lord.
Huh?
It is 23
Now 26.
years.
The 3 years, the amount will go very high.
And at that point of time, we are agreeable to make payment of 2 crore 73. The rest amount, lordship, only 1 crore or something like that.
Paying that would be more beneficial for you.
I also have lordship.
Then we can settle it out. But otherwise, if we set aside this, And directive for, because
For a
now the land has
fresh
been taken, you have to
lordship.
go for a first acquisition, which is the mandate of the clause 17.
Lordship.
Then you have the state would lose more. We are not going to give him interest because interest is not there.
Lordship.
At least 6% is okay, nothing more than that.
But,
Because there's
but
no mention of
if
interest.
their interest, they are entitled to beyond that amount of 2 crores, as because we are agreeable to make that payment of 2 crores at that point of time, they could have accepted it with
Right.
objection.
Where is this?
No,
So on
for
this-
that too, not only that,
Where is
the
this?
scheme under which they have agreed doesn't say anything about interest.
Lordship. Yes.
Now, if he wants to persist on this agreement, then this is it.
It will be better, right, Lordship.
This is the only way out.
Lordship.
These tea gardens have, if it was another person, we would have thought it differently. But tea gardens have lots of money.
Lordship.
But the state also has to honor its commitments.
Lordship. That's true,
It
Lordship.
But
cannot
once it's the
backtrack
agreement-
its commitments.
That's true, Lordship.
What we have added, we have to pass. Some interest has to be given. We are on 6 or 9%.
9%.
Maybe.
First year,
Uh,
9% for first year, and second year it will be 15%.
That, Mr.
But
Mr.
in
Mohanto,
one
that's
case,
I
Lordship,
know.
that
9 and
Pankaj
15 is
Kumar
the
Jain-
9 and 15 is the mandate of law, but you didn't go by that. You should have said that, okay, I'm not going to give it.
And again, the entire
You
thing-
entered into a negotiation. Now they are dishonoring it. When it is a dishonor, this court is here only looking into it as to whether the dishonor was right or wrong. And if not wrong, then to set it right.
But once they
If you won this court, you have come before this court in a more like a suit for a specific performance, asking them now to pay that.
No, I came because my lord, it is a long back that was acquired, so nothing has been paid. Even I
No,
personally.
nothing has been paid. You were asked to take
No, no,
that.
I approached my lord. They are not taking any initiative to pay. That is why I came before lordship.
That
Then
they-
their entire machinery has
Did
been.
you offer them the
Yes, yes,
278?
Lordship, yes.
Then the entire machinery has been set up into my lord Muson. Otherwise, they were all
2
sitting
crore
on-
73,000 accordingly, Lordship, the petitioner may submit the APR, bank details, indemnity bond, no objection certificate, etc., and the approved amount would be disbursed. That 2 crore 73 lakhs.
And what is the indemnity bond? Contents of the indemnity bond that he would have no right to claim more.
No.
Then why will he
Under
submit that?
that process, land has been required.
That is.
That cannot happen like. What to do? There are two ways. One is this or the other is that.
Then
May
I
I-
have to wait for another long period, my lord, to acquire this compensation. If he, my lord, will not say, my lord, set aside these things, my lord.
No, what you have to do if you want to do it is the only thing is you'll get the money.
No, I'll get the money, but unless and until the process is new.
We can do one thing. I can pass an interim order to that effect. He can collect that amount under protest without prejudice to his claims in this petition, and they will pay that.
Including my lord Jirat value.
Whatever amount he has found out, 2 crore 78 or whatever may be, you go and collect it in the meantime. Without
They initiate the initial process of the land acquisition again.
No, that we will see. You can collect that. But are you insisting on this?
No, no.
Because you are not asking for cancellation of that.
Yes, my
No. The
You are
prayer
not
is
asking.
prayer is-
I agree to but that amount.
So
Whatever is lying between us.
therefore, the question is you are asking for that amount only.
Yes, that's what
5
the-
crores 84 lakhs and they are giving you some 2 crores or whatever may be.
Yes, so my
So
automatically.
you are asking this. So therefore you are asking this particular amount. So when you are asking this amount, you are not asking that return me back my land.
No, my lord, they return back the land, my lord, it is a very my lord, unreasonable, my lord, expectation from my side. Because, my lord, it is a long land has been acquired, entire road has been constructed, lot of money has been invested, my lord. If I, being a my lord citizen, my lord, is being a honorable, my lord, before your lordship, I am always obliged to do whatever there. But I cannot go for this, my lord. At least if some amount.
No, Mr. Monto, I am not asking you, but this is not your prayer also.
Yes, my lord, I am
Your
not.
limited prayer
Yes.
is out here is that you want certain money.
Yes, my lord.
Now, therefore, let me pass an interim order directing him
Right.
to give you the amount, and this amount you'll receive without prejudice to your claims in the writ petition. Then you have some money with you.
My lord.
You need the fuel also to fight.
Your lordship, my lord, if you decided, my lord, I have not agreed. I fully agree, my lord, lordship, whatever.
Huh?
If lordship will decide in that way, my lord, I will agree.
No, now you take that money.
Yes, my lord.
That time I'll get him.
My lord.
See, what I want is, if they go ahead, the question is, we can, and we will say that if you receive that money also, that shall be if the respondents fail to honor their commitment, it may result to a negotiated, it will result to an acquisition, and that amount shall be taken as an advance. Because the land possession has already been taken.
Yes.
So therefore, you are protected. But if they don't come up with this proper thing, the state government, state of Assam has a lot of money.
But after all, lordship, it's a public money, lordship, in my
Yes,
view,
I-
lordship. It's a
that is why-
public money,
that
lordship.
is why I
1
given
rupee is wasted, lordship. But even then, if this type of things are done, they have to.
Public money is good, but the state also has to think that. huh?
Yes.
But on
Yes,
I have handed over my entire land before
The
taking.
council thinking it has no relevance. Chalo. Heard Mr. P. Mohanto, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma, the learned additional senior government advocate, appears on behalf of the respondent state. And who is respondent number 7?
Contractor, I think, my lord.
And Ms. So appears for the respondent number 7. The petitioner herein is aggrieved by the actions on the part of the respondent authorities. In taking over the possession of the petitioner's land, in the garb of doing so in terms with the scheme, land acquisition through direct purchase by way of negotiated settlement for all departments in the state of Assam, and having agreed to pay an amount of rupees 5 crores 84 lakhs 81,029.50, which was the negotiated settlement, and now proposing to pay an amount of rupees 2 crores 73 lakhs 3,174. Mr. P. Mohanto, the learned counsel, submitted that the actions on the part of the respondent authorities is not only contrary to the land acquisition, to the scheme, that is the land acquisition through direct purchase by way of negotiated settlement for all departments in the state of Assam, but it is also a fraudulent exercise of power by the respondent authorities referring to the scheme which was notified on 7th of March on 11th of March 2022. The Learned Counsel submitted that a settlement is to be recorded. A negotiation has to be recorded as per an agreement, which is to be in Form C and Form D for the landowners and for interested persons and other than landowners, respectively. In addition to that, an undertaking has also to be given by the landowners and or the interested persons that they would not claim for payment of higher compensation in any court of law. The Learned Counsel for the petitioner referring to Annexure 5 to the writ petition, wherein collectively various agreements in Form B1 and Form C have been entered into by and between the petitioner as well as the concerned respondent authorities. Submitted that the total amount was agreed to in respect to 39 bighas of land was rupees 584,81,029.50 paisa. The Learned Counsel further submitted that it was obligatory on the part of the state to honor the said agreement and honor this, to not only honor the said agreement, but also act in consonance with the notification dated 7/11, notification dated 7/3/2022, which was gazetted on 11/3/2022. The Learned Counsel for the petitioner further submitted that a perusal of the affidavit which have been filed by the respondent number 4 would not show that there was any fraud committed by the officials of the respondents at the time of entering into such agreements. The Learned Counsel therefore submitted that if the respondents are not agreeable in terms with the notification dated 7th of March 2022, which was gazetted on 11th of March 2022, the respondents would be bound to, the respondent would either have to return the land back to the petitioner after paying due compensation to the loss suffered by the petitioner on account of the various tea bushes which were there in the land, which were and were completely destroyed, or to go ahead with a fresh acquisition in terms with step 17 of the notification dated so-and-so, which was gazetted on so-and-so. The learned counsel further submitted that a very perusal of the scheme would show that a settlement has to be arrived at on the basis of negotiation and mutual consent. And the mutual consent agreed upon was rupees 5 crores so and so, and not the amount which is now being offered of rupees 2 crores so and so. The learned counsel for the petitioner further submitted that in the meantime, for the last 3 years, not a single penny have been received by the petitioner. Which violates the mandate of Article 300A of the Constitution, which is akin to a human right. Per contra, Mr. H. Sharma, appearing on behalf of the respondent, submitted that though admittedly there was a negotiated settlement and agreements were entered into in Form B1 and Form C in respect to the 39 bighas of land, and further that the possession of the land was taken as far back in the year 2023. But upon recalculation, it was found, upon a resurvey, it was found that the amount of compensation which could have been paid, should have been paid to the petitioner, agreed upon and paid to the petitioner, was rupees 2 crores so and so. He submitted that if the acquisition was carried out in terms with the right to fair compensation, full name to name, the compensation which the petitioner would have been entitled to was only rupees so and so, 2 crores 7. He further submitted that there is no stopping for the petitioner to accept the amount of rupees 2 lakh crore 73 so and so, provided the petitioner submits the necessary documents in that regard. Next, rejoining to his earlier submissions, Mr. P. Mohanto, the learned counsel, submitted that if the petitioner has an 6 petitioner can request, can claim, if the petitioner seeks disbursement of the amount of rupees 2 crores so and so, which is unfairly and unjustly calculated and contrary to the negotiated settlement, the petitioner's writ petition would become infructuous. And further, all rights and claims of the petitioner to get the amount which was agreed upon would be rendered authorized. He further submitted that the petitioner herein is entitled to interest at the rate of 9% for the first year after the possession has been taken. And thereupon 15% on the amount which was agreed upon. This court have duly heard the learned counsels appearing on behalf of the parties and given an anxious consideration. The materials on record, more particularly Annexure 5, clearly shows that there was a negotiated settlement as to the amount payable to the petitioner in terms with the scheme. And as per the negotiated settlement, the total entitlement of the petitioner was rupees 5 crores so and so. However, it also prima facie appears from the materials on record that the respondents herein now had made a 180-degree somersault to the promises so made to pay the petitioner the amount as per the negotiated settlement, and now offering an amount of rupees so and so, 2 crores so and so. Under such circumstances, this court have also taken note of the contents of the scheme, and more particularly clause 5 of the scheme, which stipulates that the land value under the scheme has to be fixed as per the negotiated settlement, negotiation and mutual consent. And if there is no mutual consent, the acquisition so carried out of the land of the petitioner would be contrary to the scheme as notified by the notification dated 7/3/2022. Under such circumstances, the respondents, in the opinion of this court, has 3 options. Number 1, either pay as per the negotiated settlement, semicolon, or B, go ahead with a fresh acquisition of the land as per the Act of 2013 or any other applicable provisions of law. But paying the compensation as per the Act of 2013. Semicolon, or return the land back to the petitioners along with compensation for occupation of the land and the damages so suffered by the petitioner on account of uprooting of the tea bushes. This court, therefore, grants an opportunity to the state government to reassess the three options available and apprise this court on the next date. Number 2, next. This court also duly takes note of that the land of the petitioner possession of the land of the petitioner was taken in the year 2023. This was done so even prior to the negotiated settlement. In terms of the Act of 2013, the power to take possession of the land proposed to be acquired can be traced to Section 40. And subsection 3 of Section 40 of the Act of 2013 mandates advance payment of rupees of 80% of the amount. This court also is of the opinion that this court have also given an anxious consideration to the submissions so made by Mr. H. Sharma, the learned additional senior government advocate, that the petitioner can very well collect the amount of rupees 2 crores 73 so and so by submitting the necessary documents as sought for. Mr. P. Mohanto, on the other hand, had contended that if the documents which have been sought for is required to be submitted, the petitioner cannot have a claim. Petitioner's entire claim in terms with the negotiated settlement would fail and or waived. Under such circumstances, it is the opinion of this court that in order to arrest any interest on the land, any further accrual of the interest on the amount of rupees 2 crores 73 lakhs which have been already adjudged, determined by the respondent authority, liberty should be given to the petitioner for withdrawal of the said amount, claiming the said amount under protest and without prejudice to the instant proceedings. Accordingly, this court therefore grants liberty to the petitioner herein to file appropriate application before the respondent number 3. Respondent number 3.
Yes, 4 million.
Respondent number 4.
No, my if district commissioner is in respondent 3 million.
Respondent number 3.
ADC
For Kala doesn't come here.
Lordship.
No Kala business. Before the respondent number 3, claiming the said amount, which is already being determined, claiming the amount of rupees so and so, which the respondent Number 4, which the respondents have already determined to be the appropriate compensation. Without prejudice to the claims made in the instant writ petition, as well as under protest. It is observed that if such application is filed by the petitioner, the respondent authorities shall duly consider the same and not making payment may be construed and not making payment, disbursing the said amount, upon further adjudication of the instant proceedings may be construed as reluctance on the part of the respondent authorities not to disburse the said amount.
But the amount maybe one time limit may be fixed, my lord,
What?
for releasing the amount.
You file your application.
I'll
They
file-
let them not give. This is what I'm making it out so that they come up. They don't give. I can pay you. I need also something.
my
This
lord.
is a handle for me to
My
pay the, give you the interest. List the matter again when? 28/4/2026 for further consideration.
My lord, 28. Oh. That can be on 29 or 30, my lord.
Why?
Because I'll be out of session on 27 and 28, my lord.
28/4.
Yes, my lord.
What is your problem?
April, yes, I know, my lord, April, my lord. Certain my religious, my lord, things will be on left.
Okay, 30. 34/2020. Further consideration to continue.
I apologize, Lordship, at first, not being on time. This is with regard to certain claims arising out of a contract which is disputed. However, the claims that we make is not per se from the contract, but from an order given by the FCI to supply those security persons. The petitioner is sponsored by Director General of Resettlement of Ministry of Defense to supply security guards at FCI, Lordship.
What is the agreement?
Agreement is at page 33, Lordship. 34, 34 is the start. Work order will be 33.
Yes, what did you say?
And now we supply and the number of security personnel is at page 32A is a type copy, Lordship. That is the work order, which says the scope of the work. We had to supply 34 numbers of security guards, Lordship.
The work order does not say any amount.
Does not say the amount, Lordship. The amount is as per the notification with regard to the minimum wages, Lordship, which is revised eventually. So it is with regard to the number of security guards which is supplied. The number of security guards are given at page 32A, Lordship. That is the work order. So is the scope of the work. 32A is a type copy. Lordship.
Yes. 34.
34, then 3 are supervisor, 31 is the security guards, Lordship. So now,
And
Lordship, I'll take a Lordship to annex 3, Lordship.
age.
Page is 31.
Huh?
31.
Ah.
This is the advisory which governs the relationship between the petitioner and the FCLers with regard to supply of the security guards, because the security guards are ex-servicemen which are sponsored by the Director General of Resettlement, Lordship. It says, Lordship, in 1A, a reliever has to be placed on 7-day in place of the guard working on for 6 days. Serial number L of the waste structure has to be paid to the reliever and all components to be deposited with the concerned government authorities. Lordship, this says that we should supply reliever to the each security person supplied to the FCI.
if they work for 6 days, on the 7th day, there should be a reliever which is in place of the person working for the 6 days. Lordship, with this advisory, at page 53, we make an application to the FCI. See, we may be allowed to supply additional number of 5 security personnel as per the advisory. I think that's page 53, Lords. That is a representation submitted by the petitioner.
53A.
Lordship, that is the type copy. The type copy of the reply of the FCI, Lordship. 53 would be the representation submitted by the petitioner.
Then
At 53A is the letter which permits us to supply that. It says, Lordship, it is from the FCI, Lordship, from the respondent. With reference to your letter dated 7/9/2019, that is the representation we submitted under reference regarding deployment of reliever against 34 numbers of security guards engaged in the divisional office, Silchar as per the sanction order. You are requested to deploy as per the guidelines issued by the DGR accordingly. Guidelines is the Annex 3, Lordship. Now we supply on the basis of
where's
that,
Annex 3?
page 31. That is the advisor. One reliever has to be placed on 7 days in place of the.
Circular dated 7/5, and this is 28
Lordship,
March 2016. How are you
Lord-
saying Annex 3?
Lordship, it is as per headquarters circular. That is the circular of FCI, not the circular that we relied on. This is a circular by the
Where is
DGR.
the circular?
Lordship, the representation that filed by the petitioner was relying on the advisory at Annex 3, because we are the sponsored by the Director General of Resettlement, Ministry of Defense. On that basis, we filed the representations before the FCI authorities saying that we may be allowed to supply the relievers. Now they allow us with saying you are requested to deploy as per the guidelines issued by the DGR. DGR guideline is that Annex 3. Lordship.
Yeah, that is March.
That is 2016 March.
This is 7/5/2018. Where is that?
That was not supplied to us. It is not with us also, Lordship.
Then how
They are
do
not
you know?
also annexed with the.
Why didn't you ask?
And then if,
Now what is your case?
Lordship, now we have supplied.
Then what
For-
do you want?
For the month of November to April, we have paid for the 5 relievers. Suddenly, from the month of April, they have stopped by an order at page number 88, Lordship. Now they rely on these notifications saying that we are not allowed to supply the relievers.
So
Which is,
they say,
yes,
as per date, that we have engaged 34, asked you to provide 34.
yes, Lord.
In our installations, these 34 will commensurate, even take care of the reliever.
Lordship. That is what the circular days say. However, if Lordship sees the date of the circular they rely on is of August 2019, and the order which permitted us is of September 2008.
Then where is 7/5/2018?
That was not supplied to us, though we
Then they must have enclosed it with the affidavit.
affidavit, no, Lordship. They have only enclosed the 29/8/2019.
What does it say?
That is the notification they relied to cancel the payments.
Now, is it your case that you have not given really the persons concerned who are working had to work for 7 days.
They had to work for 6 days. We supplied the reliever on the 7th day. That is the additional person which is deployed.
Now, you supplied the reliever
Yes, Lord.
on the 7th day.
Yes, Lord.
So they are not paying for the reliever.
They're not paid the reliever charges. That is,
They are not paying for the reliever, or are they not paying for the 7 days?
they're not paying for the reliever on the 7th day, not the reliever, Lord. Because a person will not be working after the 6 days as per the guidelines. So 7th day, we also have to supply the security guard. So they were already supplied. Services were available, but not paid for that particular day.
But you supplied it from the reserve 34.
No, Lord. So we have deployed additional 5 security
So
guards.
how do we know, in the court of days, that these people were not the same people who were there on the 6 days?
That would not, that would be difficult on my part to place who worked on which day, until I obtain instruction specific with regard to that, Lordship.
No, because the fact remains, you are referring to that particular
Yes.
document of 2016.
Lordship.
That also provides one thing,
Yes,
that a person will work for 6 days
Yes, Lordship.
and one day will be the,
Reliever.
you will get a reliever.
Yes, Lord.
2019 also says the same
Yes,
at
Lord.
page 104, more particularly 7 and 8.
Yes, Lord. This equal strength.
6, 7, and 8 says the same. So therefore, there will be a reliever. But they also say that that should be from your same pool.
Lordship, that would be answered probably by Lordship page
So
55.
therefore, you have to show that there were 34 stations. Against these 34 stations, you had 34 persons.
Lordship.
And in these 34 stations, for one day, for 5 days in a week, 5 days in a month,
Lordship.
there were 34 persons appointed.
Lordship, that would be answered by page 55. It is on a rotation basis, so it will not be 34. It is 1/6 of the total number of.
Therefore, the question is, if 1/6 is there,
Lordship.
it is on rotation basis, it will be continuing out there. Means, is there any other person being appointed for that?
Yes, Lordship, that is number 5 numbered. 1/6 of the total strength, that is 31 security persons, 1/6 will be
So
5.
how many posts were there to be
31.
manned?
31, Lordship, of the security personnel. And
How many posts were required to be manned? The security persons are there.
Lordship, we are,
In one post, how many posts, security guards are there?
for scope of the petitioner was to supply the security guards, and that is where to be employed will be on this domain of the
So do
FCI.
you have any document that they are saying that these persons concerned have already exhausted the 6 days in a week?
No, Lordship, we do not.
And 1 week, one person therefore you employ?
Lordship, no, we do not.
Then
have.
on what basis did you provide that?
From the advisory and the representation and the order.
Advisory categorically says
Yes,
you have to give them 6 days.
yes, Lordship.
So therefore, where is your document to show that these were the 31 persons who were the security guards?
Lordship.
These 31 persons were employed, they are doing as per rotation.
Lordship.
The rotation, it is done on the basis of rotation. Once the rotation means you are having on one day how many?
Lordship, that,
These are questions of findings of facts.
Lordship, that is correct.
These needs to be shown out there before the civil court, not here. We can't help it.
Lordship.
What happened last time? Another similar matter came.
The petitioner has withdrawn. Lord, same query was made by your lordship, and he has withdrawn ultimately.
Because what happened? That is another aspect. Now, what happened in tea gardens? One day is off. That is mandatorily required to be given 1 day off.
Yes, Lord.
But when the salary is, minimum wage is fixed, minimum wage is fixed as 7 days. The equation is like this. Let's example, a person is to get 3,000 rupees per day, 300 rupees. Let us make it simple. I'm weak in maths. 300 it will be calculated into 7, 2100 divided by 6. The 6th is his working. So his minimum wage will be calculated accordingly, which will be 2100 divided by 6 is 3, 18, 350. So his salary, daily wage will be 350. And thereby taking care of the 7 days. This is how things work, how minimum wages are fixed in the tea garden.
Sanction in his name and paid to the reliever.
So it is already given for him for the 7 day, but the minimum wage is fixed in that manner. I don't know that, but I think what facts you are stating out here, these are facts which needs to be entertained before the learned, before the civil courts, wherein you have to ask for these amounts like this. So you have to show on evidence that it was in the rotation, it was on the basis of rotation basis. There were 31 persons, of which these people will have to be on rotation basis. If he works for more than 1 day, 6 days in a week, so the rotation happens in such a manner that that he works for 6 days in a week, not more than that. So that the 7th day you have to get hold of somebody else to get it for getting that extra, because otherwise you don't have. So therefore you have to say the rotation does not work in this manner unless you have somebody else to replace those persons. So these are findings of facts which I can't look into it. Heard Mr. D. Dekar, the learned counsel, appearing on behalf of the petitioner, Mr. P.K. Roy, assisted by so-and-so, represents on behalf of the respondent number 1 and 2. The grievance of the petitioner herein is that the petitioners were not paid for the reliever on the 7th day of the week by the respondent authorities, which was contrary to the guidelines issued by the, what is DGR?
Director General of Resettlement, Minister of
Director General of
Resettlement,
Resettlement,
Resettlement.
which the respondent numbers 1 and 2 were bound to do so. The materials on record show that a work order was issued to the petitioner for deploying 34 numbers of security guards, which consisted of 3 supervisors and 31 unarmed guards. It is an admitted fact that these security guards are required to be deployed on rotation basis. On the other hand, also Mr. P.K. Roy, the senior counsel appearing on behalf of the respondent, submitted that the guards who were asked to be deployed was deployed by the petitioner was taking into account that the reliever on the 7th day would be amongst the 31 security guards who appointed. The question therefore arises as to whether the 7th guard, the guard who acted as a reliever was one amongst the 31 security guards. Or the petitioner had to engage somebody else, taking into account that the 31 security guards deployed would not commensurate, would not be sufficient for not be sufficient to act as a reliever on the seventh day. These aspects, these questions, the said question can only be decided in a proceeding where evidence can be led to the effect as to whether the whether the 31 unarmed security guard were sufficient to act amongst themselves as a reliever for the seventh day, or the petitioner had to appoint some other guard, had to deploy a fresh guard, another person, other personals to act as the reliever. Considering this would involve various disputed questions of facts which can only be adjudicated in a forum wherein evidence can be led, this court is not inclined to entertain the instant writ petition. Accordingly, the writ petition stands dismissed. It is, however, observed that the dismissal of the instant writ petition shall not preclude the petitioner to approach the competent court of civil jurisdiction. And the period during which the instant writ petition has been pending, that is since so-and-so, 5/10/2021 till date, be excluded while computing the period of limitation.
Deep blue.
A.Y. Chaudhary, where is he?
Lordships wanted me to get the instructions regarding the inquiry report.
You filed affidavit.
No, I have received the instructions only.
What is that?
The instructions said the inquiry report was not furnished.
Funny.
But one aspect of the matter, may I just point out to your lordships? Kindly have a lordship issue the charge sheet, the allegations.
What is that?
Page, my lord, 18.
Page?
Page 18, my lord.
Yes.
Two sets of allegations, my lord, trying to influence the judicial officer for appointment of his nephew and to arrange money so that nephew's appointment can be facilitated. And in the inquiry, my lord, he has admitted the allegations. He has admitted in his written argument.
No. He has admitted the allegation. That is why the inquiry report is given. Well, but the fact remains that he has an objection. He has a right to object to that.
That's true.
And then you are to consider.
Well, that's true. Yes. I'm not.
So therefore, we set aside the penalty and direct you to start by giving him an inquiry report and proceed. That is why I will give away short notice.
That's true. That's true.
Because keeping this matter unnecessarily pending makes no sense. Because if he is to be terminated for whatever he has done, it is for law.
True. That's just for your lordship's knowledge, I have indicated this.
However egregious the facts may be, it does not change. The law is to be law.
That's true.
So they allow your petition and put it to the stage of issuance of a show cause notice, second show cause notice, giving you the inquiry report, asking you to reply, and then they will take a decision.
Within a time frame, my lord.
That is your lookout. You give it. You don't do it. You don't. That is your lookout. You want to keep
There
it.
are instances, my lord, wherein there are instances wherein my lord, things went on for
This
this.
is something, what submissions you made is similar to a submission made by the Advocate General before this court at the time of when me and Justice Chaudhary was hearing the Salakuddin matter.
Lordship.
Said that let this court hear all these matters as to whether they have a bona fide right of claim over the thing. And I said, why? We should look into it. Let the authorities know.
That is also-
No, nothing is going to happen.
I withdraw, my lord. I withdraw.
But may I
Lordship,
submit something?
will require the instructions, my lord.
But, as per your lordship, how we have decided, my lord, that is the fact, my lord, I also admit. But regarding this V. Karunakaran judgment, my lord, if this is followed, my lord, then I also, my lord, pray for the benefit which I have lost, my lord, for this.
What benefit?
That is consequential.
That they will look into it. You will be put under, you are under suspension.
Dim suspension it will be.
That will be
As per FR 54.
Reduced salary also, my lord. That's all.
Now you have been reduced salary only.
No,
No,
compulsory.
no, that is, my lord, the amount which is now he's getting, my lord, there is also at the time of the order, passing the order, my lord, compulsory retirement,
Hmm.
my salary also reduced, my lord.
That they will look into it. Don't worry. Once that happens, first you get hold of this compulsory retirement out.
Yes.
Thereafter, you have any benefit, you come over. Leave will be granted to you thereafter. But not this way. You cannot have club up all issues together. The issues is one has to be pinpointed to it. You are not given the liberty to ask anything under the sun.
That is right, my lord. If the order itself is illegal, my lord, that which they have
The
done.
order of compulsory retirement is illegal. Inquiry is not illegal. I'm not touching upon it.
Yeah.
I will give him, we set aside giving them the liberty to proceed from by issuance of a show cause notice, giving you a inquiry report and to submit whatever it is.
Yes, that is.
Heard Mr. A.Y. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. H.K. Das, the learned standing counsel appearing on behalf of the Gauhati High Court. And Mr. S.S. Roy, the learned government advocate appearing on behalf of the Judicial Department of the Government of Assam. The petitioner herein is aggrieved by the imposition of penalty of compulsory retirement, the major penalty of compulsory retirement. Imposed by the
Page 49.
wait,
49, Annexure 7.
Date is at page 50, 25/3/25.
imposed by the respondent number 3. Respondent number 2. Respondent 2 or 3?
Respondent number 2.
This is a penalty order or what?
Yes, my lord.
Yes.
District and session.
Imposed by the
Judge Qatar
respondent
sits.
number 2. Then he filed an appeal before whom?
She's
Huh?
He filed an appeal before district and session judge, my lord.
Why? If the district and
it has
session
to
judge pass
go-
the order,
It has to go to the secretary
okay.
as per rule.
And that has not been finalized.
No, no, he has not filed, in fact, before the secretary. He has filed before the district and session judge.
is aggrieved by the imposition of penalty by the District and Session Judge Kachar, Silchar, dated 25/3/2025, by which the petitioner was imposed the punishment of compulsory retirement as per Rule 7, Roman 5 of the Assam Services (Discipline and Appeal) Rules 1964. The petitioner thereupon filed an appeal under Rule 15, 15 or
Yes.
19? Rule 15.
I'll just confirm.
I do, Rule 15 and 19. Of the said rules of 1964. Before the same authority.
Rule 13, my lord. Rule
No, not Rule 13.
No, it's district and session judge establishment. Every member of a service shall have the right to appeal from the orders of district and session judge to the government, that is secretary to the government of Assam Judicial Department.
Before Rule 30.
Rule 13, 1-3.
1-3
Of district and session judge, Assam District and Session Judges Establishment Ministerial Service Rules 1987.
However, the said appeal was not considered on the ground that the same was filed in the wrong forum, isn't it? Wrong forum.
No, it's not that. He did not even file before the proper forum.
This is the document he has filed now. Where is that? Annexure 8.
Yes. And he issued a reminder, page 62 to the secretary. So it is for the secretary to take a call.
Appeal under 13 has to be filed before whom?
10-4, page 57, my lord, it was to the district and session judge, to the secretary, yes.
So it will be filed before the district and session judge and it will be transmitted to the secretary, isn't it?
Yes, my lord. Lord,
The
why
said
this
appeal,
confusion?
was filed
10-4-25 is the appeal
before
file.
the office of the district and session judge to the district and session judge Kachar Silchar for transmitting it to the secretary, Judicial Department, Government of Assam for consideration. However, the said appeal remained unconsidered, and under such circumstances, the petitioner has approached this court. The case of the petitioner in the instant proceedings the petitioner in the instant proceedings, though have challenged the imposition of penalty of compulsory retirement by the impugn order dated so and so 25/3/2025 on various grounds. But taking into account the allegation made in the instant writ petition that the petitioner was not provided with the inquiry report, before imposing the punishment of compulsory retirement, this court, without going into the merits of the, without going into other aspects, would take up the instant appeal, instant writ petition for disposal on the aspect as regards the legality and validity of the impugned order of punishment dated 25/3/2025 on the ground that the inquiry report was not provided to the petitioner prior to the imposition of the impugned order of punishment. This court, by an order dated 9/2/2026, sought for instructions from the respondent authorities and more particularly the Gauhati High Court, more particularly the respondent number 2, as to whether the inquiry report was furnished to the petitioner when the second show cause notice was issued by the disciplinary authority. Mr. H.K. Das, the learned counsel, appearing on behalf of the petitioner, respondents number 2 and 3 submitted. That the inquiry report admittedly was not served upon the petitioner when the show cause notice was issued by the disciplinary authority asking the petitioner why the petitioner should not be imposed penalty on the basis of the inquiry report. It is the opinion of this court that taking into account the above, the impugned order of punishment dated 25/3/2025 cannot be sustained in the law in view of the judgment of the Supreme Court in the case of Managing Director ECIL Hyderabad and others versus B. Karunakar and others reported in 1993, 4 SCC 727. Under such circumstances, the instant writ petition stands disposed of with the following observations and directions. The impugned order of punishment, impugned order dated 25/3/2025, by which the petitioner was imposed the punishment of compulsory retirement, is set aside and quashed. Number 2, the petitioner, prior to the impugned order of punishment, was under suspension, and as such shall continue, and this period and the period from the date the petitioner have been inflicted with the punishment of compulsory retirement till date shall be construed that the petitioner was under suspension, and accordingly the petitioner could be entitled to such amount, would be entitled to such subsistence allowance as permissible under law, after deducting any amount of pension if the petitioner in the meantime had been paid. He must have got provisional
FR, my lord, it will be deemed suspension, my lord. He suspend now, after this, my lord, he'll be in deemed, he'll deemed
Into deemed suspension. This court further grants liberty to the disciplinary authority, that is the respondent number 2, to issue a show cause notice if, on the basis of the inquiry report, the disciplinary authority is of the opinion that any further action is warranted. It is further observed that in the circumstance, the disciplinary authority is of the opinion that on the basis of the inquiry report, there's a inquiry report. A proceeding, a case of penalty is made out. The petitioner be issued the show cause notice, and if so done, the inquiry report be furnished to the petitioner. This court further observes that thereupon the disciplinary authority shall do the needful as per the provisions of the Assam Discipline and Appeal Rules 1964, read with the District Establishment Rules 1967.
87. Ministerial.
87.
My lord, I prayed for
The instructions which is kept on record and marked with the letter. Yes.
I prayed for reinstatement.
Are you not suspended? I put you under suspension.
Under the law, the provision is that if the termination or dismissal order goes, my lord, penalty order goes, and fresh show cause notice is to be issued, he'll be in deemed suspension, my lord. That is the law. Highly appreciated.
Also, in this matter, I tender my humble apology. Yes, on the last occasion, I was unable to attend.
Okay, tell me what to do with him.
Actually,
he's
initially,
able-
when the
he's
petitioner has
using-
approached the court,
Huh?
on the very first day when the petitioner has approached the court, on that day, we have asked for an inspection, and based on that inspection, we have filed an affidavit saying that the parameters as prescribed for ambient sound control pollution. So that has been maintained as regard the residence of the petitioner concerned. And if at all we go to near the boundary pillar or his gate, then the parameter is somewhat higher.
67.
Yes, yes. So this is what is the stand as per this affidavit. So this is a small fabrication unit, and that apart, on the last occasion when the matter was listed, it was on 27/10/2025. So then the court wanted an inquiry for me to find out if at all the respondent has been operating without a consent to operate. So initially they have obtained the consent to establish way back in 2016. So on that basis, finally, we have made an inspection and it found that the unit was functioning without the consent to operate, in fact. So finally, we have issued them notices to that respect and asked them to apply for proper consent to operate and also to comply with all the parameters as prescribed under the consent. So that notice has been served upon me, but there was a little delay from November till now in issuing that notice. So that notice has been issued and rest part will be taken care of by the board.
If they don't have the consent to operate.
Yeah.
If I'm not wrong, the consent to operate is not a one time.
No, time to time.
It has to be renewed.
Renewed.
Now, if they have not renewed it, can they proceed?
No,
They have to, without the consent to operate, they have to close down.
no, they cannot. They cannot operate.
They have to close down.
They have to close down.
We have the consent to operate as on now. Huh?
Rina. Even though the unit is a small, so far I understand it is a fabrication unit where the
fabrication work are being carried out, but this is what has transpired. This.
So it has been issued now on 24/2.
Yes.
Okay, so let's see what happens. You apply as per this. You are working out there, so you have to apply as per for the consent to operate. See what happens. The question is not that. The question is not what the petitioner is being affected in his house or not. But whether the mandate of the pollution laws have been violated or not.
That's true.
If he had, you are of the opinion that he can still apply for a consent to operate. And if you give him a consent to operate, that is a different aspect of the matter. Because you see, the petitioner's right not to have a disturbance from him cannot be with unfettered.
No, that
It
cannot.
would be subject to reasonable restrictions.
Yes.
The restrictions are, he follows the mandate as per law.
Yes. Yes.
So the petitioner having a problem that I am having a lot of problem with the sound out there. If it follows as per the mandate of the law.
Then there
help
is
it.
nothing stopping them. So that's what we have stated in this notice also. Submit documentary evidence of compliance with environmental norms and pollution control measures adopted. So
I think we'll put it after some time and see what he does. He has been asked to submit a report within 15 days. Let us have it in the month of April. And in the meantime, you do the needful.
yes, yes.
Warning.
Lordship, may I give for the press noise monitoring report? Also, it was done in way back 2017-18.
You want to carry out a monitoring report?
No, monitoring report because now it has been, our instructions is some increased that part. Some they have,
You get a report. When did you get this report?
that report, what they have submitted in affidavit is 2017 report, Lordship. What we are relying on.
No, they will. Therefore, now they didn't have the consent to operate or renewed consent. So they have been asked 15 days to wait along with compliance. They will look into it. That is why I keep the matter pending. Otherwise, I would have disposed it off.
Yes.
The trusts upon the pollution control board being less, I have not disposed. Heard Mr. Escapodar, the learned counsel, appearing on behalf of the petitioner. Mr. Escova appears on behalf of the Pollution Control Board of Assam. And Mr. So-and-so, who appears on behalf of the respondent number 9. To stop. Mr. Escova, the learned counsel, submitted that the respondent number 9 initially had obtained the consent to establish on 13/1/2016 its unit, but did not obtain the consent to operate, which is mandatorily required. Under such circumstances, on 24/2/2026, a notice was issued to the respondent number 9 to apply for valid consent to operate to the Assam Pollution Control Board within 15 days from the receipt of the said notice, and further submit documentary evidence of compliance with environmental norms and pollution control measures adopted. Mr. DC Nath, the learned counsel, submits that he is not aware as to whether the notice have been received by the respondent number 9 or not, taking into account that the same was issued only on 24/2/2026. But however, he had received a copy of the notice today from Mr. S. Purva, and the said 15 days therefore can be counted from today for compliance. Seeking taking into account the above, let this matter be again called up on 23rd of April 2026 for an update as to whether the respondent number 9 had applied for the consent to operate within the period from 15 days from today, and whether the consent to operate have been issued by the Assam Pollution Control Board. The notice which have been issued to the respondent number 9 is kept on record and marked with the letter X.
Meetings.
Good. Yeah, you are challenging the
Cancellation.
yes.
So the entire case is on the basis of some report, and where it has been said that the status of the certificate, genuineness status of the caste could not be ascertained clearly. If your lordship will kindly have 19, page number 19. The
Your
second
father was who? Who was your father?
my father was Vijay Bahadur Swarnakar.
Where is your father's certificate?
He did not avail of the benefits of this at any point of time. Only my uncle had taken the benefit, and during the inquiry process, when I was asked to submit the credential, there I submitted a certificate issued in the name of my uncle.
Uncle means
My paternal uncle,
father's brother.
father's brother.
How do you relate your father's brother to your father? By documents?
They asked for the NRC documents.
Understood. You have to show me that there is a linkage somehow. The father is obviously, you are giving it to the father's brother. So the father's brother, you have to link it somehow that he is the son of so and so.
Well, my case has been on the ground that the cancellation after 20 years of issuance of the certificate, that is in contravention of the prescription in Madhuri Patil's case.
What does it
Madhuri
say?
Patil's case and the subsequent cases have said that only if it is ascertained that the certificate was procured by way of fraud, then only it can be reopened, otherwise no. Now, the committee report, the CID report which the committee has relied upon, that does not say that the certificate was obtained by fraud. It only says that the status could not be ascertained clearly. And substantially, my lord, the report of the CIT was also never furnished to me. The complaint on the basis of which, my lord, this inquiry was undertaken, that was also not furnished to me. If they want to proceed with an inquiry in pursuance of the mandate of Madhuri Patil's case, my lord, then at least the the complaint and the report has to be furnished to me. Otherwise, I am unable to meet the points.
Where the reports have been given?
No, reports have not been given, nor the complaint has been given to me. It shows that there was a complaint against the certificate and therefore an inquiry was ordered. But neither the complaint nor the copy of the inquiry report was furnished to me. In the affidavit, although they have said that it was furnished to me, but they also shy away from annexing the copy of the report to the affidavit. And my specific averment in the writ petition that it was never furnished to me, that has not been denied.
But you are to show something. You were asked to show cause. What are the documents you submitted before them?
Documents is only, my lord, the uncle's caste certificate.
But how do you relate your uncle to your father? Because he writes Sonar, you write, your father writes Swarnakar or something.
Swarnakar.
Then how do you relate?
Basically, my lord, it's a variation of the same title, same surname.
Oh,
Variation of the same surname. But
why did your father write Swarnakar and your uncle write Sonar?
Yes. My lord, it's a variation of the same
So somewhere it has to be, some linkage has to be shown. You have failed to do so. Where is the inquiry report, madam?
The inquiry report is composed of the petition. This one, the one who is assailed in this petition is at page 19, my lord, this order.
No, I'm not on that. It
The
is based
CID.
upon our CID's inquiry.
That report is not with me, my lord.
Why you have not brought the records?
No, my lord, records are not there.
Records are necessary.
Records are not also.
Hmm.
My lord, as many as 3 occasions, she didn't appear, my lord. As many as 3 occasions when she was summoned to by the committee, she didn't appear before the committee. And then finally, when she appeared, she did not supply any document to substantiate her claim. And then she was asked to produce any additional document if she has. That also she didn't do.
And this NRC document, application form received Moon Swarnakar. Application submitted so and so, birth certificate number 3, electoral roll. What is this NRC? When were you born?
70. He's around 54 years now, so around 72.
I know date of birth also in this. If I understand correctly,
she was born on
the dictum of
5175.
Madhuri Patil is to get rid of these false claims, and therefore a committee was set up because of the illegalities being committed on gross issuance of the SC/ST certificate, thereby depriving the actual entitlement to those persons who are entitled to.
Yes.
Madhuri Patil. They have formulated that instead of going to various other places, you have a particular committee. The committee will decide. And the committee will give you a cross-examination, and all these things will be given, the right of cross-examination if any document is given.
Yes.
But the fact that you did not appear there, when you were asked to show cause, you were asked to be, you appeared, the fact that you did not appear.
But I had taken time. Once I had appeared, and thereafter I had taken time because of certain flood situation in the area where I was staying. And it was thereafter that they passed the order.
No, what was the flood situation there? Here it was said that the order was passed, he was asked to appear on 18/9.
In the
First
affidavit,
on,
28/9.
in the reply affidavit.
first on
Many-
8/4,
So many times the notice has been issued to you.
then June, and then in July, and then in August also.
Yeah. Such the committee directed here to produce documentaries such as NRC as well as other separate documents. Now, why NRC was sought for? Because the NRC was to show the linkage
Link.
between your father and that uncle, that they are belong to that. There is no document to that effect.
Malad, that is absolutely correct, Malad. But
Then-
what
Now, therefore, how can you rely upon your uncle's certificate?
now, Malad, what I am on is that if you are relying on certain report.
Forget
based
about
on
the
which you are
report.
che-
Forget about the
Yes.
report. The
Now
fact
that-
remains, no, forget about the report. The fact remains that you have been given an opportunity to produce the NRC linking your father to your, because when you were having your own NRC, you must have given your parentage.
Yes.
And the parentage, not only that, it has the inclusive of the family by which 1950, your grandfather or great grandfather was there in that particular, in the 1950 NRC.
What I otherwise feel, Milord, NRC or perhaps would also not be of help in the case.
The
The reason is this.
NRC was the easiest. That is why they have given. In fact, for me also, I think NRC should not have been given.
Because Milord,
NRC was the most easiest thing to prove that
No.
there was a link between your father and your paternal uncle. You have
Yes,
not proved
yes,
that.
yes, that is true. But then to ascertain the status of the caste, Milord, the status of the caste.
Status of the caste, no. The caste, Bonia continues to be an SC. There is no quarrel with the proposition.
Yes,
But whether you belong to a family which has an SC or not, that is to be, because your father did not have a certificate.
now, Milord,
So
assuming-
therefore, how does one know that your father was an SC?
Now, Milord, since there is a difference in the title of my uncle and that of mine, Milord, what I submit is that, Milord, ultimately the decision as to whether the Bonia community includes the Swarnakar or not.
No.
That
Many people may write it. Many people may write Swarnakar. Maybe you have, just for example, Borua, you have many people, you have various castes also. Swarnakar is
even the spellings also, Milord.
Swarnakar or Sonar,
Yes.
or even Borua, I'm telling you. These are certain titles being given by somebody.
Yes.
Or Pukon, if you put it, these are all titles being given. So he may have a different caste. So therefore, under such circumstances, the question is you are to show that your uncle concerned was the person who was issued a SC certificate because he is your paternal uncle. And as such, how do you link your paternal uncle to your father? The moment you show that, then they will be satisfied. You fail to do that. Neither you have produced any document before me. So what is the perversity in this?
Milord, my perversity is only with regard to this, Milord. You are acting on a report. You are not sharing the report with me. You are acting on a complaint. You are not sharing it because Madhuri Patil says, Milord, if it is based on some report, then report has to be given to me. And thereafter only my chance of meeting the points will come. You are relying on some report. You are relying on some complaint. You are not giving a copy of it to me. And you are cancelling my certificate, which was issued after due process long 20 years back. And in the subsequent judgments are there, Milord, where it has been said that if a certificate has been issued after due process, then it should not be reopened merely because there is a complaint. Unless and until
Merely
fraud.
because of a?
Merely because there is a complaint. Unless and until, Milord, there is a fraud.
No, that cannot be the judgment. Let us see.
Milord, may I just
Well,
read this page, Milord?
Where does the Supreme Court says that you should not open merely because of it is a fraud? The moment you are getting a certificate and being not entitled to,
If your
and
lordship,
then also getting a certificate, it is a case of fraud.
yes, my lord, it is only permissible to reopen only in case of fraud.
So therefore, the moment you are getting a certificate of an SC without there being without your entitlement is a fraud. Not only a fraud upon the person, is a fraud on the constitution.
Yes, my lord. My lord, this is para 8, my lord. But Question is that if fraud has been alleged, my lord, at least I am required to know, my lord.
I don't think the constitution ever says to that effect that a person who is not entitled to be to belong to the SC or ST would be, if issued a certificate, the court should not reopen it.
My lord, para 8, last sentence, your lordship, may kindly see. In that para 8, I am reading from the beginning. In Dayaraman, the court was of the view that scrutiny committee is an administrative body which verifies the facts and investigates into claim of caste status. The orders of the scrutiny committee are open to challenge in a proceeding under 226 of the Constitution of India. Further held by the court that permitting civil suits with provisions of appeals and further appeals would defeat the very scheme and will encourage the very evils which the court wanted to eradicate. It was observed that the entire scheme in Madhuri Patil will only continue till the legislature concerns make an appropriate legislation in regard to verification of claims for caste status as SC/ST. It was made clear that verification of caste certificates issued without prior inquiry would be verified by scrutiny committee. Such of those caste certificates which were issued after due and proper inquiry need not be verified by the scrutiny committee. Now, my case is that, my lord, it was issued 20 years back. Now, if today you are saying that there is a fraud and therefore it
No.
will be
Now
gone.
tell me whether it was done with the proper verification.
Yes.
Show me that.
Now, my lord, that was 20 years back, my lord.
So, if it was 20 years back, but then also you cannot have a right to have a caste certificate unless you are entitled to.
That is why, my lord, at least they are required to give me the copy of the complaint, give me the grounds on which they are saying that this is not the caste certificate was not granted properly. Unless and
No,
until
you
this,
say that there is a proper verification.
no, that is my assertion, my lord. Now, if they are saying to the contrary, my lord, unless and until they give me the basis on which they are saying the contrary, I cannot meet the point. NRC is NRC is one of the ways of ascertaining the linkage. But whether or not the caste certificate was genuinely issued to me, since they are questioning it today.
No, not genuinely. Caste certificate was issued after proper verification.
Yes. Now, if they are saying that it was not issued after proper
So
verification.
you are going to accept it.
No, at least they have to.
The
give
matter
me-
ends then.
No, at least they have to.
You say that.
They
No,
have
the
to- they
moment
have to-
it is there.
Well,
if
they
it
have
is
to
no.
give me the reasons.
No
At least
case.
they have to give me the reasons.
Sorry, no case. Not a case for this court to entertain.
Unless
This
and
is
until,
just-
unless
The
and until.
scope of this court's jurisdiction is very less. For here they came into a report to the effect or made a complaint by the one complainant who was the president of this SC community out there, who says out here that this person concerned does not belong. On the basis of that, it was picked up. And thereupon, you were asked to produce the necessary documents.
That complaint or the report is also not made.
Why
part
do you
of
need the
report.
complaint? Just assume it that he says that it is not there. Then you are to therefore show, the burden is on you to show that you belong to SC, because you see, the privilege which an SC or certain privilege is being given to an SC or a ST is because of the fact that they have suffered disadvantaged. They were disadvantaged on account of the long harassment, mistreatment which they have received. So under such circumstances, you have to prove that you belong to that category of persons, and as such, you have been given. The only document was to show that your father was, your uncle was there, that uncle is the brother of your father.
Well, in that case,
Anki, you have also not produced from the fact that what is your father's name?
well, in that case, if your lordship would grant me one opportunity to approach them, at least they should revisit because of the.
Mr. Dutta, it is a very nice way to say. Earlier you were saying that on the question of principles of natural justice, that means they will give you the report and then you appear, which I'm not satisfied. Now, therefore, you say that now give me another opportunity. It is the same thing. It is one and the same thing. One is on the basis of some violation of the principles of natural justice, and the second is a question of mercy. Mercy is just outside the door.
My lord, keeping in mind the factual scenario, Miller. For one reason or the other, there was a lapse on my part. I could not, for whatever reason, Miller, I could not appear. Now
You
they
do
are
one
taking a
thing.
drastic.
No, I can do one thing if you do. File an additional affidavit bringing on record the linkage. Then I'll ask them to reconsider. And if you don't have that, no case.
In that case, Lordship may grant me some time, Miller.
That is the only best thing I can do. What do you say?
My
Then
lord.
I will direct them to reconsider,
Ma'am.
have a look at it.
Ma'am.
Not on the ground of the
We also
inquiry.
wanted the same thing, that you produce additional document if you have anything. But
No,
for the-
firstly, I have to be satisfied
Ma'am.
they have a document to the effect. Bring it on affidavit by additional affidavit. We'll see on that day what happens. But otherwise, no mercy. Mercy is not there.
Any date after Holi, Miller. Any date after Holi.
But holy, I'll have it after Bihu also.
Well, that will have some difficult.
No,
Some
I am
consequence
asking,
on
I
me.
am giving it to you.
Well, that
You
will-
want it after Holi. Holi you can take Bihu or even the Durga Puja. Whichever you feel like.
Well,
The
that will
aspirant for-
visit me with adverse consequences.
Have you not been visited
More-
with
more adverse.
adverse consequences till now?
Well, it will be more adverse. It will be more adverse. That's why any date, Millard, after Holi, Millard, subject to your lordship's convenience, if 10th March or
I'm giving you this additional opportunity on a superlative decree being used to a word adverse. Heard Mr. S. Dutta, the learned senior counsel, assisted by Ms. S. Roy, appearing on behalf of the petitioner. Ms. P. Chakraborty appears on behalf of the Social
Justice Department.
Justice and Empowerment Department of the Government of Assam. Mr. S. S. Roy appears on behalf of the respondent number 2 and 3, 2, 3, and 5. The issue involved in the petitioner herein have assailed the order dated 31/10/2025, whereby the caste certificate which was issued to the petitioner on 11/6/2010 was cancelled on the ground that the petitioner failed to produce any document to substantiate that she belongs to the scheduled caste community. This court have also perused the materials on record, and on the basis of these materials, as well as on the basis of the materials so produced, this court is also prima facie not satisfied that to interfere with the impugned order, be that as it may, taking into account the submissions made, that the petitioner herein was disadvantaged on account of floods to produce the necessary documents before the state level committee. State level caste committee, na? The state level,
Scrutiny Committee.
what does it?
State
Screening
level
committee.
Scrutiny Committee.
This court grants an additional opportunity to file an opportunity to the petitioner to file an additional affidavit, bringing on record as to whether any documents exist which could correlate the petitioner with her uncle, correlate the petitioner with Miss one Dinesh Sonar, whom the petitioner claims to be her uncle. When
10th March.
10 March, lot of matters, 10th of March. Take a kinder judge, 19 March.
Let it come before your lord.
Kind judge. On list the matter on 19th March 2026 at 2 p.m. The additional affidavit, if any, to be the petitioner is given a liberty to file the additional affidavit on or before 13th March 2026. Look, hearing me. चलेगा सर 2 p.m. huh? What to do? We'll take your matter later on. We have a hearing. Yes, Mr. Pranvar, argue.
My lord, by this writ petition, I'm now the impugn order at page 48, which is the subject matter of the writ petition.
Where's the impugn order?
That is at page 44, annexure 3, my lords. Annexure 3, my lord. Now, lordship will find this order, which will be passed by the deputy commissioner. Page 40 of my writ petition, my lord. 48, 48.
Yes.
That is the orders, my lord. Now, on the last part, my lord, therefore, well, I'll just skip all this paragraph 1, 2, 3, 4. Then I come to the therefore, in view of the seriousness of the case, until the matter is produced before the competent court or judicial magistrate, the premises Mohabi requires so and so, situated at so and so, so and so, so and so, is hereby directed to be temporarily sealed, my lord, for the sake of ongoing investigation. Now,
What is this concept of sealing?
sealing means that the concept of sealing means they have been sealed this one, my lord, now locked. They have locked.
What is the power of the district magistrate?
No, my lord, there's no, that's why I have no power, my lord.
What is the power of the
Under which
district
provisions,
magistrate
my lord?
to seal it?
Lordship will kindly see.
What is the power of the district magistrate to seal? I understand the police. I understand the court in respect to a criminal investigation. What is the power of the district magistrate to seal?
Well, in fact, the order, Lordship, at page 48, the order at page 48, this itself is clear, my lord. Under what, this itself is clear, under what circumstances, my lord, that order of temporary sealing was done.
No. What is the power of sealing?
Now, ultimately, my lord, the district magistrate. if
You have a power of attaching. There's a power to attach.
Lordship.
When there is an offense being created, it's a case of an offense.
After investigation.
In relation to an offense, what is the power of the district magistrate to seal?
Well, in fact.
Attach is another thing.
Lordship.
Now, BNS can do it.
But during search and.
It may BNNS and BNS both. Taking the oath. Not this one. And the other one. Other one is BNS. ठीक कहते हैं एक ही कौन एक ही कौन तो मध्य चलो हुआ तो दियो ना हाँ
Under BNSS section 107, BNSS.
What is the power in respect to a criminal investigation for the district magistrate to see. My question is that.
No, but,
Because what is the district magistrate doing? He's entering into a fray of a criminal proceeding, investigation.
but,
Does he have the power to do that?
no, but in fact, Lordship may kindly allow me to read the page 48.
I've read it.
Page 48.
Yes, I've read it.
But in fact, during the search and whereas the search and seizure was conducted in the premises of Mahabir Equa and Mahabir Chemical situated at Chatabari by the inspector of CID in presence of circle officer, because during that was during investigation. While search and seizure, my lord, the district magistrate was requested that you please depute someone, and
You
during
the
search,
district magistrate may only permit
search and seizure.
search and seizure.
During investigation, there was search and seizure. And that time, at that point of time, the IO, he requested the district magistrate that, and therefore in presence of circle officer and executive magistrate, Soigaon Revenue Circle, and neutral witnesses in connection with investigation of CID PS case number so and so, the search and seizure was done. Then, whereas the investigating officer CID.
Just wait 1 minute, huh? If it's so difficult for you to get a BNS, or should we ask the councils to give us a copy of it? The High Court administration is inefficient. Yes. Search and seizure. Let's see search and seizure. Where is the provision of search and seizure? You have a book?
No, Malad, there earlier, there's no such 106, Malad. Malad, Lordship may kindly take up 106.
Okay, I'll rise because these people are incapable of giving me a book.
No, Malad. Malad, your Lordship will
I'll rise because of this. Let it be put. Let these
Malad,
people be put into
106,
disciplinary.
earlier 102, Milord, was the provision in CRP.
No, Mr. Borat, 102 is different from 107.
No, 102 was
102
in CRPC, Milord.
provided a power of seizing an air, but that was just movable properties which could be
Yes,
done
Milord.
and put in the Malkhana or the police station out there.
That
Nothing
what-
more than that.
Under the reference, Milord. it has
But
been-
107 is different.
107 is
107,
different.
the power of attachment is there, forfeiture is there.
106, Milord, the power of police officer to seize certain property, Milord. That is 106, Milord.
কোন কোর্ট আছে বিএনএস কোন কোর্ট Attestation BNS 2 on BSA. Call the librarian. Librarian.
So,
yes.
106 is the power of the police officer. Lordship will kindly see the power of the police officer. 106 to seize certain properties. Any police officer may seize any property which may allege to be or suspected to be stolen, or which may be found under the circumstances which create a suspicion of commission of any offense. Such police officers, if subordinate to the officer in charge of a police station, shall forthwith report the seizure. Lordship kindly see, of the police shall forthwith report the seizure to that officer. That officer, that is a police officer. Every police officer making under subsection 1 shall forthwith
report the seizure to the magistrate which have a jurisdiction where the property seized is such it cannot be conveniently transported to the court or where this difficulty in securing proper accommodation for custody of such property or where the continued to retention.
Why
of the
do
property.
we need 106?
My lord.
Why do we need 106?
My lord, your
It is
lordship
a,
asks the power of.
Mr. Bharat, don't digress from the
I'm
point.
sorry.
We are concerned with the power of the district magistrate to seize, to seal. Where is the power of sealing in a criminal investigation? My question is this.
There's nothing in this, my lord.
It is not
Said
there. So
nothing.
under such, we set aside this. And now you have filed an application before that. You can file an interim application out there also. You see, 107 says attachment. Kindly see this. When there is an urgency is also there, that can be done without even notice. There's a power also there, no?
They have filed, my lord, and the matter has been fixed on 2nd of.
May issue a notice upon the demand where the notice upon the year specifies any property has been held by any person on behalf of such person or copier. The court may, after considering the explanation and so and so, provided if a person does not appear before within a period of 14 days, so and so. Anything, and if the opinion that issuance of notice on the year would defeat it. So you have 107(5). So as per that, you can file an application if you want. But you see, what is to be done has to be done by law, not by these district magistrates doing all this thing. They have taken the law to their hands. We set aside this. You are at liberty. There is already a proceeding there. And apart from that, you are at liberty to file a 107(5) if you wish. That pending hearing, in view of the setting aside of this order, pending hearing, you can very well be at liberty to file an application seeking urgency. And the court may consider as to whether it is a proceed of the crime or not. Yes, yesterday you were saying what? Proceed of crime is not defined.
Defined, my lord. In the definition of BNSS, except Chapter 8. And Chapter 8 is relating to reciprocal arrangements, my lord, between.
Let us look into BNSS.
Yes, my lord.
Wait.
The lordship may first come to, my lord, the definitions. There has to be definitions, my lord. What is the proceed of crimes, my lord? Definition from 2 onwards. Chapter 8. 111. BNSS. Except there is nothing about that.
Kindly see 2.2 of BNSS. Words and expressions
Yes.
used herein and not defined, but defined in the Information Technology Act 2000 and the Bharatiya Nyaya Sanhita 2023 shall have the same meaning assigned to them in that act and Sanhita. Meaning thereby, acts as a bridge between BNSS and BNS.
Right. Now,
Let-
I'll just, Your Lordship.
Wait.
Yes.
Does the BNS does not define proceeds of crime?
Yes. No. No. Except below chapter 8, my lord, of BNSS. That is section 211 of, that is for the receipt, that chapter is for the reciprocal arrangement, my lord. For assistance certain matters in the procedures, attachment and forfeiture of property regarding my lord, the countries, my lord. That is 211, my lord. Sorry, I'm sorry, 111, my lord. Neither BNSS nor BNSS proceed of crime has not been defined, my lord, except PMLA.
Very good. আপনারা check করবেন what has happened. If people they don't have the necessary in a court of my years, we don't have the BNS. I think it's the most shameful thing which can happen. Criminal manual এখন রাখি চুরি বসে হ্যাঁ it offense. So, therefore, I don't need the evidence. Yes, going on to chapter.
Chapter 8, my lord, that is chapter 8, section 111, my lord. There's a reciprocal arrangement, my lord. The chapter is relating reciprocal arrangement for assistance certain matters, my lord. The chapter comes, my lord. Here the procedure of crime has been defined. And it is stated what is contracting states, my lord, has been also defined.
It is already there.
Yes, well, but
111C.
11, that what I want to point it out. So for that chapter, this chapter, my lord, chapter is A, my lord, in the BNSS, my lord, under the definition, there is no any definitions clauses. So for the procedure of crime is concerned. Now, in BNSS or CRPC, there is a chapter, one by one, the chapter 8 has been newly brought into and has been reciprocal arrangements between, my lord, has been regarding assistance of certain matters.
This is not only reciprocal arrangement for assistance in certain matters and
procedures.
And procedure for attachment and forfeiture of property. Now, forfeiture of property and attachment is there already out there in section 107.
107, that is for,
So
but if your lordship
107,
kindly
the
see,
procedure is already there.
My lord,
The power is there.
well, it is regarding power is there, regarding it is outside the countries. It is what my submission is this chapter is for, not for the outside India, my lord. This chapter is for, made for the outside India, my lord.
No, it cannot be.
My lord, if your lordship kindly see what it says, the contracting state means the country or places outside India, my lord, in respect of which arrangement has been made by the central government with the government of such country through a treaty or otherwise. The chapter is for that only, where the procedure of crime has been defined.
No, see 115.
My lord.
115.
Yes, my lord. Assistance
Where
in
a
relation
court
to
in India
no, property,
has
any court of India has
reasonable grounds to believe that any property obtained by any person is derived or obtained directly or indirectly by such person from omission of any offense. It may make an order of attachment or forfeiture of such property as it may deem fit. Under the provisions
of
of section
116
111 to 122.
That is under this section, not 107. So not in 107. That is under 116 as well. The procedure is totally different, my lord. The procedure is a general procedure, so far the 107 is concerned. So definitely here, your lordship will find it will definitely say that 107. They say that 116 to 122.
And this particular chapter is what, 105 onwards?
Is, well, if your lordship kindly see,
This is under what chapter?
chapter 7,
107.
my lord. Chapter 7. After
Process to compel.
yes, my lord. Process to compel the production of things.
It is there. Then search warrants.
My lord. That's how it's going, the procedures.
Power to even. Then general provision relating to searches. Recording of miscellaneous offense of power of the police officer to seize certain property. Attachment for features so and so.
That what is provided under section 107, my lord. So for that is within the countries.
So you say that chapter 8 is only in respect to reciprocal when it is outside.
Yes, my lord.
With a
Lordship
contracting country.
Yes, lordship kindly see 15.2, my lord. It will, sorry, 115.2. That will make clear, my lord. 152, 15.2, my lord. My lord, just I read, where the court has made an order of attachment or forfeiture of any property under section 1, that is, my lord, 111, my lord, and such property is suspected to be a contracting state, which has been defined, my lord, contracting state. The court may issue letter of request to the court or an authority to the contracting state for execution of such orders. So 15.2 is absolutely clear, my lord, so far, my lord. Chapter 8 is concerned, my lord.
And there is no offense in the BNS relating to proceeds of crime.
No. Nothing, my lord. And most, my lord, I'll just highlight one thing. The prosecution, if they started with 107, they say the proceed of crimes. Now, during the course of trial, the 6 says that you have a power to distribute the proceed of crimes amongst the person who. Suppose in the course of trial, doesn't find that I'm acquitted and this is not a proceed of crime. How will you restore? No provision for restoration also. No provision for restoration also. Under 107.
107 says,
my lord,
if the
I
court
agree.
or the magistrate finds the attached or seized properties to be proceeds of crime,
My lord.
the court shall by order direct the distributor to ratably distribute such procedure to the persons who are affected by such procedure.
Fine, stop here. Okay. Now,
your lordship will kindly see, during the course of trial, either it's an ex parte orders or prior also, during the course of trial, and in course of trial, I found I am acquitted, and my lord,
So there is
that I
therefore,
found that this is not a proceed of crime, it's my money.
so therefore there is no corresponding provisions like in PMLA.
Yes, my lord.
When there is an adjudication done under section 8,
Yeah, my lord.
thereafter an appeal lies, the appellate authority, then an appeal lies again to the High Court under 42.
Yes, my lord. Right.
So there
Absolutely.
is no corresponding provision.
Nothing. That is what I found, my lord. So for the BNS account, because they want to add, but they have forgot to add other.
Anyways,
Anyway, but
we
that is not
we are
our
not on that point today.
my lord.
Let us not digress.
And,
to
and,
that.
and my lord, we'll not have.
If I do it anywhere out there,
Well,
then why should I go into that today? I'm only looking into this particular order. Because the district magistrate jurisdiction will only spring at the time of 107(6).
Yes,
Not prior that.
But here, my lord, here the main accused is not before your lordship. The person against whom the case is going on, he is not before your lordship.
Who
Here
is
the
before?
here the company is before your lordship, and company says
no. Petitioner. Partnership form. It's a
Mah-
partnership form.
Mahabir Equa. It is the Mahabir Equa, my lord. It's a firm.
No, whether the firm has been affected or not. Because
Yes,
remember
no,
one
affected.
farmer.
Paragraph 4. Paragraph 4.
This is the company, the thing belongs to whom? Mahabir Aqua and Mahabir Chemicals situated at so and
Yes.
so. Mahabir Aqua has come
Mahabir Equa has come.
and done by one partner who is your partner. Number 2 is a partner.
Number 2 is the partner.
So,
And paragraph 4, kindly see, they said that the prime accused Siddharth Sharma had invested an amount of rupees 1.1 crore in that company. So, my lord, in the affidavit, we have, while filing in fact, in our affidavit, we have said in paragraph 13, but during investigation, it revealed that Siddharth Sharma was a salaried person and his earning is monthly 57,000 rupees per month. And my lord, ultimately, we found that he had made huge investment in that particular company.
but
Therefore,
Mr. Nath, shouldn't it be better for all these arguments in the trial court?
No, that's true. I am just indicating the background facts, my lord. Kindly see the situation at that point
Tomorrow,
of time.
just for example, let's example.
My lord.
Somebody has some proceeds of crime and he invests in a mutual fund. Mutual fund is very big.
Yeah.
Somebody invests them. And tomorrow you say that no, we seal the mutual fund, the entire fund, taking into account somebody has deposited some amount.
But it was 13/10/2025 order. It was at the time of when the investigation was going on. There was then a request was made by the IO that for search and seizure, some order has to be required at the temporary measure. That was done, and in fact, the order last para says
I should have known the BNSS. He appears to be similarly situated like me. My problem is IO is always there with the BNSS. I am there with my land laws.
Also, Lord, I want to point out one thing, Lord. My lord, I have
But what Mr. Pranbora is saying, I think there has to be an answer by the legislature, and it is there. I don't need to look into today how you link the proceeds of crime with taking into this, because there has to be. And in fact, when I was once asked to give a speech on the BSA, taking into account BSA is similarly with the Indian Evidence Act. And the best part about that, as I could notice is, see, when it is section 5 in the BSA, it is section 3 in the Indian Evidence Act. So there is an addition of 2 sections which are there. I'm saying not about 5 and 3, it happens in section 21. But there is a change. Otherwise, it is just 2 sections beyond. BSS. So there is no problem with that. But BNS is, I was never asked to give any speech. So for me to look into it was not necessary. And anyways, the thing remains, but what I could find from a reading of BNS is what the government have done or the legislature have done. They had incorporated the safeguards which have been given by various Supreme Court judgments and incorporated it, and thereby giving certain. Now, for a proceedings under, they may have to give these proceeds of crime out here or these attachments which are there or anything to relation to this, they must have given the local court also, apart from the adjudicating authority under PMLA.
Yeah.
Now, the PMLA can only function in respect to the schedule offenses. Not beyond that.
Not beyond that.
So therefore, in certain offenses, because what was happening was at one point of time, and this became more necessary. At one point of time, everywhere, the court was, there were various judgments of the Supreme Court which were saying that this you cannot insert, that you cannot insert. And therefore, unless you can't have 120B unless you have that corresponding schedule offense. These had a lot of problems. So these must have necessitated these to be brought within the form.
107.
So, but I think if you look it properly, although I'm not today necessary, it is not necessary for me. One can find out how the correlation is. Anyways, Mr. Nath, have you got my judgment on the insurance matter?
Well, I have seen.
See, why I'm saying so, because of the fact that we have in Assam, we have the Assam Motor Vehicle Rules 2003. This was done when 166(3) was not there. And therefore, there was no requirement what is to be done. But with 166(3) coming in, the state also has to be proactive like the center. Center have done it. They have brought 150A and as well as Annexure 13. State also has to have a look at the judgment because you were appearing. Because there I said, I formulated certain guidelines. And I said that till the rules are not being made or amended or revisited by the state, you need to follow this.
True.
This is it. But it would be better for the state to take a course.
If the rule comes.
Yes, because what has happened, these things are required. And I have one thing good was that particular notification which you have brought, by which this disciplinary proceedings, then it will give some teeth to that which has happened.
Correct.
So therefore, have a look and kindly advise your government on that.
Yes, sir. Definitely.
It would be, then it will go on a long way for the claimants also. Because I held that when a person has to approach the court to file an application after 6 months, it means that within the prescriptive period which has been given in the Act and the rules, the investigating officer as well as the insurance have not done their work. So, although he cannot claim that this particular, the claim petition cannot be entertained, but it can always be taken as a complaint petition and raised as a miscellaneous application. Because the miscellaneous application idea, you again get it in Rule 8, Clause 18 of the Annexure 13. When the moment you are filing a FAR, it becomes registered as a miscellaneous application. So there it is how it has been given. So have a look at it because that is necessary for the state to do it.
Correct.
Anyways, let us now dictate no more.
No more. Just one point.
Enough. I have other.
Yes.
See, the High Court matters are there.
The only thing is that
you see that Mr. Gupta is waiting for some contractual matter. Mr. Arbor Pujari waiting for some revenue
30
matter.
30 seconds. Logic
30 seconds.
Good.
Okay.
My paragraph 12, I say.
Taking it your name, I am giving you 30 seconds.
Paragraph 12.
Obviously, the first thing.
Paragraph 12, where I have stated the order has no jurisdiction as absolutely illegal, to which they have given a reply that they do not have any comments on their affidavit. I,
Why are you making the 30 seconds, spoiling the 30 seconds of the other
no, no,
lawyer?
no, all-
He's also agreed, I am also agreed, everybody is agreed.
Madam,
But this order is without jurisdiction because the district magistrate only come into action in 107(6). Heard Mr. Pranbora, the learned senior counsel assisted by Mr. H.K. Sharma appearing on behalf of the petitioners. Mr. Dina appears on behalf of the respondent numbers, all the respondents. The present petition has been filed challenging the order dated 13/10/2025 issued by the District Magistrate Kamrup, whereby the petitioners premises were sealed for the sake of ongoing investigation. From a very perusal of the impugned order, it is apparent. From a very perusal of the contents of the impugned order dated 13/10/2025, it is apparent that certain search and seizure were conducted at the premises of the petitioner at Chatribari under Boko Police Station by the Inspector of Police CID bracket Investigating Agency /IO of the SIT bracket close in presence of the Circle Officer and EM Soigao Revenue Circle in connection with CID-PS case number 18/2025 registered under section 61 bracket 2 oblique 105 bracket 1 oblique 106 bracket 1 of the Bharatiya Nagarik Suraksha Sanhita. No, these sections are under the other one, no?
BNS, no?
It has been wrongly written, no?
No, these are penal provisions.
It should be under the other one, no? Bharatiya Nyaya Sanhita.
Lordship. This is
Nyaya
They have been
Sanhita.
BNS.
not BNSS.
Correct.
They have been wrongly written as a B.
2023 bracket wrongly written in the impugned order as Bharatiya Nagarik Suraksha Sanhita 2023. Read with section 103 of the Bharatiya Nagarik Suraksha Sanhita. For short, take it according. It is further seen from the impugned order that on the ground of seriousness of the case, the district magistrate temporarily sealed the premises of the petitioner. The short question which arises in the instant proceedings is as to whether the district magistrate, Kamrup, had the authority and jurisdiction to seal the premises of the petitioner. This court, during the course of the hearing, inquired with the learned counsel appearing on behalf of the respondent, under what provision the said power was exercised, taking into account that the power to seal is not available to the district magistrate under the Bharatiya Nagarik Suraksha under the BNSS 2023. The learned senior government advocate submitted that the power can be traced to section 107 of the BNSS. He further submitted that in the meantime, the state have also filed applications before the competent court seeking an order of attachment in terms with section 107 of the BNSS. And the said matter is presently pending. He further submits that in the circumstance the impugned order is set aside, there is a strong likelihood that the said properties which have been sealed would be lost and the proceeds of the crime and the properties which are nothing but proceeds of the crime arising out of CIDPS case number 18/2025 would be difficult to be retained for initiating further proceedings in terms with section 107 of the Act of the BNSS. Per contra, Mr. Pranbora, the learned senior counsel who appears on behalf of the petitioner, submits that the district magistrate Kamrup had no jurisdiction or authority to pass the impugned order dated 13/10/2025. He submitted the role of the district magistrate would only come after there is an attachment and a further forfeiture of the proceedings by a court of law, by a competent court of law. And that too only to distribute amongst the persons who have suffered on account of the proceeds, on account of the crime. In that regard, he has referred to subsection 6(7) of section 107 of the BNSS. This court have duly heard the learned counsels appearing on behalf of the parties and have also perused the materials on record, including the respective pleadings before this court. A perusal of the impugned order shows that the district magistrate Kamrup, that is the respondent number so and so, had sealed the premises of the petitioners. On the ground of an ongoing investigation of CIDPS case number 18/2025. The power to seal, attach, seize are powers which have to be conferred by statutes. In the instant case, it would be seen that there is a power to attach under section 107 of the BNSS. The court finds it very pertinent to reproduce the said section. Conjoint, a reading of the above quoted section would show that for the purpose of initiating a proceedings for attachment, forfeiture, the police officers should have reasons to believe. Police officer making an investigation should have reasons to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from the commission of an offense. In other words, such satisfaction cannot be based upon vague assumptions, but on the basis of materials available with the police officer conducting the investigation. The police officer conducting the investigation further on its own cannot file an application seeking before the court or the magistrate exercising jurisdiction to take cognizance of the offense or commit for trial or try the case on its own, but has to take the permission from the superintendent of police or the commissioner of the police, as the case may be. Next. It is further seen that the power to attachment is not merely dependent upon the police officers making investigation, having a reasons to believe, but it is also dependent upon the court or magistrate having reasons to believe as to whether before or after taking evidence that all or any of the properties for which the application is filed seeking attachment are proceeds of the crime. In that regard, it is the requirement of subsection 2 of section 107 that a court or the magistrate may issue a notice upon such person calling upon him to show cause within a period of 14 days as to why an order of attachment shall not be made. A further reading of subsection 3 and subsection 4 of section 107 shows that the person who have been issued a notice under subsection 2 of section 107 of the Act of the BNSS has a right to provide an explanation as well as place the material facts available before the court or magistrate. And the court or the magistrate has to give a further reasonable opportunity of being heard to such person or persons, and thereupon can pass an order of attachment in respect to the properties which were found to be proceeds of the crime. It is also pertinent to observe that a proviso to subsection 4 of section 107 further mandates that the court or the magistrate also has the power to pass an ex parte order, have a power to proceed ex parte should the person to whom the notice have been issued do not appear before the court or the magistrate within the period of 14 days specified in the show cause notice. This court also finds it very pertinent to take note of subsection 5 of section 107. Inasmuch as the power to pass an ex parte order without notice under subsection 2 of section 107 is solely vested upon the court or the magistrate, as mentioned in subsection 1 of section 107 of the BNSS, and not upon the district magistrate. This power can be exercised by the court or the magistrate when the court or the magistrate is of the opinion that issuance of notice under subsection 2 of section 107 of the BNSS would defeat the very object of attachment or seizure. Therefore, from the above, it is apparently clear that the impugned order dated 13/10/2025 is an order passed by an authority having no competence or jurisdiction. This court also finds it very pertinent to take note of subsection 6 and subsection 7 of section 107 of the BNSS, inasmuch as the role of the district magistrate comes once there is an opinion rendered by the court or the magistrate that the goods which have been attached or seized are proceeds of the crime and not prior thereto. Under such circumstances, in view of the above, it is therefore clear that the impugned order dated 13/10/2025 cannot be sustained in law, as the same have been passed by an authority having no competence. Next paragraph. This court also finds it very pertinent to take note of the submission made by Mr. D. Nath, the learned senior government advocate appearing on behalf of the respondents, that there is a proceedings pending before the court. The trial going on or what? Is a trial or
Trial has not started.
is not committed?
Not committed. Trial has not been started. Only
Where
the
is the application pending?
application in the district judge.
Page
only.
75.
Matter has been
before the-
committed, my lord.
So it is before the trial court.
Before the
Trial
session,
court.
before the session just
Submits
comes.
that, huh?
Before the session.
Oh,
trial
come
court.
from Metro.
Submits that before the trial court, before the trial court, an application has already been filed, which is pending adjudication. Application has already been filed for attachment and or seizure of the properties, which were the subject matter of the impugned order dated 13/10/2025. It is the opinion of this court that such application taking into account, considering the above, the incident with petition stands disposed of with the following observations and directions. The impugned order dated 13/10/2025 passed by the District Magistrate Kamrup impugned in the instant proceeding is set aside and quashed. Number two, the setting aside of the impugned order dated 13/10/2025 shall not affect the proceedings pending before the learned trial court pertaining to attachment or seizure of the properties which were the subject matter of the impugned order. Number three. Anything more? Hello? This matter should have been passed on that date itself, first day, second day.
The only thing is this, because they have make a seal, my lord, there has to be the seal, my lord.
The respondent authorities, more particularly the district magistrate, is what is that?
Respondent number 4.
The respondent authorities, more particularly the respondent number 4, is directed to forthwith deseal the properties which were the subject matter of the impugned order upon receipt of the certified copy of this order and not later than 3 days. তার পিছত হেতু লিখিব shall not affect.
Like,
বুঝছো কে গম পাইছো এনেকুৱা আজকালি কোনো না বিচাৰি নাপালে বৰ দিগদাৰী নহলে সিহঁতক খিনি বিচাৰি কেনেকে পায় ending.
no, no. Wait.
Yes, Mr. Nayak, your matter. They are not appointed, these people are appointed by the government. Direct. Without the intervention of the High Court.
Selected through APSC and appointed after selection by the APSC. The latest advertisement, I have got one advertisement of 2008, my lord. It says.
Because what happens in MACT, these persons are appointed by the High Court to the Central Recruitment Center. Basically,
Ministerial staff.
we are all with the ministerial staff only.
Yeah.
So therefore, MACT is on a different league altogether.
My lord,
The register of an MACT, they have it, may have a claim. So what happens, as I could see in many of the cases out here,
Yeah.
it is appointed on the basis of a central recruitment cell.
Yeah.
And then they are then being posted out there as per the as how they are in the merit list. So therefore, their thing is different from the petitioners out here who belongs to the other one.
My lord, if I may, my lord. My lord, if I may, my lord, in respect of the other ministerial staff in the Industrial Tribunal and Labour Court, they are also recruited through the centralized recruitment. My lord. I have mentioned that in my additional letter. It is
Those
only
other
the-
persons who are appointed in the labor court are being done to the High Court.
Yes, my
Is it?
My lord, I have said so in my additional affidavit, page 216.
My lord, is it done to the High Court? The other appointments to the High Court?
I've annexed the advertisements, ma'am.
Perhaps
Page
not, ma'am.
216, ma'am. Of my additional affidavit.
Which one?
Page 216, my lord. The additional affidavit, my lord, filed on 3rd of February 2025. Para 3, my lord, I have listed out all the advertisements and I have annexed it. From page 220, page 222 are the advertisements. Page 222, it is addressed to all the courts, including the Industrial Tribunal and the Labour Courts. Next one is the
Now, Mr. How do you take care of this 222? In the reference, you see to Labor Court Dibrugarh. See, Labor Court Gauhati, Industrial Tribunal so and so. Now here, but here there is no post.
My lord, may come to page 224 onward.
Or one is there.
Yes, my lord.
222, one is there, na? Dibrugarh Labor Court,
Yes.
typist.
Maybe.
How will it be your appointee?
No.
Are you only holding the right over the register?
Yeah, my lord. He is trying to draw an inference with regard to the fact, my lord, that if these appointments, this recruitment and promotion are being controlled by this honorable court in exercise of the powers under the constitution. So as a natural corollary, he comes within the same footing. Now, but if we, my lord, delve into the matter on the particular facts, admittedly, he is not appointed by the mechanism, my lord, evolved by the High Court for recruitment or promotion of this kind of, my lord, employees.
No. You see, this order which I will pass is not going to involve him. It will have a far-reaching consequences on everybody.
No, well, Lordship will kindly see, let him.
So should we therefore say that as he is not appointed by you, he is being appointed by you, but other people could be given the same thing?
Therefore, all these courts are different establishments. We are now concerned with the industrial tribunal.
We are concerned with there. This is why I'm saying labor court. Labor court and industrial tribunal are one and the same. They are both made under 7A.
No, 7A, that is true, but here it is stated, my lord, that it is stated about the vacancy position. But so far as, my lord, recruitment is concerned, I do not find.
From page 224 onwards, my lord.
Kindly see 224.
224.
224, if my lord may come to page 225. Serial number 20, he was an underqualified steno in the office of Presiding Officer, Labour Court, Dibrugarh. He is appointed as a steno grade 1 in the office of District and Session Judge, Sibsagar. Then serial number 28, my lord. underqualified steno in the office of presiding officer, Industrial Tribunal, Dibrugarh, appointed as a steno, grade 1 in the office of the presiding officer, Industrial Tribunal, Dibrugarh. Then next page, my lord, serial number 34. Steno grade 3, presiding officer, Industrial Tribunal, Kamrup, is appointed as steno grade 1 in the same organization. Then, my lord, the second table in that same page, my lord, serial number 1. He was, my lord, steno grade 3 in the labor court. He is appointed as a steno grade 3 in the district and session judge. Then, my lord, may again come to page 229. This is in respect of computer typist. My lord, page 229, serial number 3 and 4, labor court establishment, industrial tribunal establishment. Then next page, my lord, page 230, serial number 11 and serial number 17.
And now, on the basis of this, these people are getting their salaries.
Yes, my lord.
There's no fresh appointment on.
But these are subordinate I can understand, my lord.
What is this subordinate ministerial anymore?
Because the post of registrar is the highest post in the.
Maybe, but they all belong to the ministerial. There's
But
no
then-
subordinate ministerial there.
Therefore, ministerial, but that is the final post, one and the final post at that level, my lord. That if I am appointed in the post of a registrar,
So therefore, you are saying that only the post of the registrar, the state government has the control.
maybe,
That can't happen.
maybe because we do
It
not.
cannot happen because how can you have retained only power over the minister?
Why
Registrar?
why
It will
I-
have a far-reaching consequences. Means his disciplinary action would not be taken up by the High Court.
Therefore, my lord, we'll have to lift the veil in my respectful submission. My lordship will kindly behave, my lord. Because he has been appointed through a due selection process, my lord, conducted by the APSC, which is not the fact for in respect of these persons. So therefore, with regard to the post of registrar in the
Now tell me one thing.
tribunal, there must
So the
have been
post of
some
the
decision.
registrar is a direct recruit post.
Yes.
On what basis do you say?
My lord, the recruitment, it's not a promotional post, my lord. The recruitments have all along been made by the APSC. My lord.
No, understood. Under what provision? There has to be some provision
My
somewhere.
lord, there was a creation of post. Other than that, there is no service route.
So these persons have been appointed, the typist and all.
My lord.
Here, a registrar. What are the various posts in the labor court?
My lord, registrar, stenographer, then my lord, the copyist, typist. My lord.
So all these are, rest of them have been appointed.
My lord.
Only the registrar remains who is outside.
My lord. And in fact, even in respect of the copyist and the other staff, there is no other service route.
But they are being appointed by the High Court of
By the
Central.
High Court after the Shetty Commission, my lord, through the centralized recruitment.
Don't bring Shetty.
My lord, I'm sorry, my lord. I'm sorry.
Now, my lord, something in tandem with what he has submitted has been spelled out in our affidavit, in the finance department affidavit. If lordship for a moment, maybe please to come to page 121. If I may read out, my lord, few paragraphs of my affidavit. I'm traveling, my lord, with pages.
Who?
My lord, before that, lordship may kindly see.
Your
my lord,
page is which page?
my lord, 118. I will read from paragraph 6, my lord. Paragraph 6. Something has been spelled about, my lord, the committee also, my lord. The anomaly committee, my lord, if I may read it, my lord. With regard to so-and-so, I'm saying independent basis, say that the pay scale of registered labor court and industrial tribunal was so-and-so, so-and-so. The pay scale was enhanced to PB4, which corresponds to the scale of so-and-so. It is stated that the Assam Pay Commission 2008 had recommended a grade pay of rupees 5,900 corresponding so-and-so, but the same was not accepted by the 3-member committee constituted to examine the report of so-and-so. That is the anomaly committee. The committee, upon scrutiny, did not find sufficient justification in the pay commission report regarding enhancement of grade pay for various posts, including the Register of Industrial Tribunal Labor Code. The committee therefore opined that such posts may be assigned
grade pay corresponding to the then existing pay scales. It further directed that the concerned department should undertake a feasibility analysis of individual cases and submit detailed proposals to the finance department with proper justification in the light of paragraph so and so. Now that paragraph have been reproduced here.
Committee observed
Then-
that with respect to many important recommendations, the justification was not found in the report. So which department will provide?
Judicial department.
How? You say that he is labor.
No, labor, but so far as the post of registrar is concerned, Lordship will kindly see the further statements made in the paragraph, my lord. Maybe, my lord, I have not been able to, my lord, put up my plan. It is stated that subsequently upon receipt of a proposal from the labor department.
Yeah, see, labor department has come.
Therefore, my lord, Labor Department, the matter was examined in detail and grade pay of rupees 5,400 in payment was granted with effect from February 2012. This was done keeping in view that the post of registrar is a direct entry post and to maintain a uniform standard across the state. The highest permissible entry level grade pay was considered as per general recommendation of Assam Pay Commission 2008 report. Down below, my lord, it may be mentioned that the nature and mode of recruitment of the two posts are fundamentally different. The post of Registrar Industrial Tribunal Labor Code is a direct recruitment post filled through the Assam Public Service Commission APSC, whereas the post of Chief Administrative Officer in the District Judiciary is a promotional post. Eligibility for promotion to the latter requires a minimum of 3 years of continuous service in the cadre of senior administrative officer or head assistant under the district judge or judicial magistrate. This distinction is in appointment, qualification, and promotional hierarchy clearly establishes that the two posts are not equivalent. In view of the above, the post of Registrar Industrial Tribunal and CAO of District Court stands on entirely different footings. Then, my lord, paragraph 7 speaks of city commission's report recommendation. Lordship will kindly turn to the next page, 122, my lord.
So what you are giving the benefit as per the 37/2012 is only to the others where the High Court has appointed. Now we are having only one
Yes,
post now.
Yes, yes.
Only
See,
one post was left out.
so now from all these facts which appear, that only one post is outside
Yes, only one post.
the scheme of the entire High Court.
Right.
What do you say, Mr. Das? Only one post is outside. But how can it be done in that manner?
Even the ROP rule also contains ROP rule also, Milo. The register post is there in both ROP 10 and ROP 17. It's a difficulty, Milo, but has been Milo, separated.
Now why there is only one post? Means that means the High Court has no control over him.
It appears to be so. From the materials laid before the Honorable Court.
We will be looking into which, under whom we will be looking into? Department of Labor or what? Huh?
2017. It's taking up 2017.
2010.
10. 10. Page number 337.
His book. 337.
Take the department, labor, serial number 4.
Industrial Tribunal.
Yes.
See, they
There's a-
put the presiding officer there, register there and record keeper there. So record keeper is also out. That day I was looking into another very interesting judgment on a challenge to certain tribunals. It was the judgment, it's a recent judgment of Justice Gauhati and all. Okay. But this judgment says that when you are having a particular person as an alternative to the High Court to man the tribunals, his salary has to be corresponding to the High Court judge. What is that judgment? This is a constitution bench. The recent one, not the rule. There it was held that this particular some act was there. What was that act? People reading so many judgments, they compare, forget. Madras by House. Madras Bar Association. The Madras Bar Association says, yes. There the question arose. Anyway, that is not to be on the page. That's not like this.
I thought that also inquire about the number of, about the posts there in the tribunal and labor court, my lord. The post creation, I have put it at page 32, my lord, of the writ petition, my lord. What are the posts there, my lord? It was on the creation of post.
32.
Page 32 of the writ petition. My lord,
Creation of
presiding
posts
officer,
of
registrar,
industrial tribunal
stenographer,
and active to see
my lord,
detection.
lower division assistant, typist, grade 4 is 5. For labor court, my lord, presiding officer, registrar, stenographer, upper division assistant, lower division assistant, grade 4.
Okay, no, here therefore you get one thing very interesting. They are put at the status of an officer, not the ministry. This is a very important document. They are put at a status of, they are not ministerial, the register. It is. Page 32?
Yes.
Officer post with scale of pay.
Yes.
Presiding officer, register. Staff post with scale of pay. Stenographer, upper division, lower division, typist, grade 4 and all. These are put at ministerial.
Yes.
So here he is a post
Yes.
of an officer. So he therefore do not come within the ambit of, therefore he retains with them. And if we see then 7th, the post has been created.
There is one another mode of there is one another mode of fundamental distinction because ROP does not include the cadres and pay scales of the ministerial staff.
No, therefore this,
Yes.
no, this
And-
document makes it clear.
And
The foundation of everything. Whatever is there subsequent.
Now, he is created as an officer,
and my
not a
lord,
ministerialist.
By the labor department.
And now in that regard, again, let us see.
The origin is in labor.
No, now let us see therefore. So therefore, all registers, whenever it is being appointed, it has to be appointed by the APSC.
Done by the concerned department.
The post creation here also it is being done.
Here it is by the labor department.
Huh?
This is the place technically by the labor department.
Labor department.
yes,
So if
No, you cannot say because the other ministerial is also being created by the labor department. Ministerial is also being created here, na? So if I go by what you are saying, that makes no sense here. Because if we go on the basis that the labor department has created the post for them, for ministerial stuff is also here.
perhaps my lord, the genesis has to be looked into, the genesis of creation of the post of registrar in industrial tribunal.
The only
There, my lord,
fundamental
the
difference I find,
My lord,
therefore, let us see again that 3012.
and in the ROP also, my lord, the exclusion has been called out.
Therefore, they are putting the two posts.
Two posts, and
Two posts, they are putting three posts. The record keeper post is not here.
in the issue is not that registrar is claiming parity with the CAO. Case case.
That is very difficult there with this.
That is the main issue. Now, in whatever.
No, Mr. Das, I understand. It's for me to write a, I can finish up the issue immediately. There's no quarrel with that by rejecting his case, taking into account. But my only concern is that would it affect the jurisdiction of the High Court
yes,
in regulating the labor court?
yes,
You see, it is not a small issue for him. The moment I say that, okay, he belongs to them, it is a post creation by them, then tomorrow the High Court would have no control. If the registrar does anything, the registrar says that, okay, tomorrow I'm not going, because he's the main head office. The disciplinary control is out. Wouldn't it be out? You see, the High Court would not have the control.
because my lord, at that time, when this post of register was created, we assume it. What transpired in the mind of the government? That record perhaps those material will perhaps be required. Because otherwise.
No, this appears to be done in consonance with, because why the consultation?
Yes.
7A consultation with the Assam High Court for the presiding officer
Yes.
is only qua the district judges.
Yes.
Okay.
Yes.
Why the Assam High Court here is required? Because of the fact that Assam High Court would be sparing its officials to go there on the basis of a deputation.
It is true, but those are that is with in respect of my lord the presiding officer. Here is a case, it is not a presiding officer. They are subordinate, my lord, they are ministerial staff. Now, what prompted or what transpired in the mind of the government? What is the record at the time of creation of that post? That will clinch the issue because that is.
But
that,
if we
that will be the
see
broader issue,
no,
my
but
lord.
if we see 1966,
Yes.
now let's see the Industrial Disputes Act.
Yes.
Yeah.
Yes. Yes.
This creation is being done immediately after the amendment being carried out. You see, amendment was carried out in Assam
Yes.
with effect from 1962.
Yes.
Okay.
Yes. Yes, my lord. Yes.
So now after 1962,
Yes.
this has happened in 66.
Yes. So if we see my lord section 7A.
Now what has happened is, in the meantime, because normally without this thing, you see, AA is only relevant for the purpose of district judges.
Yes.
He has worked as district judge or so and so or both for a period of not less than 3 years or is qualified for appointment as a judge of a high court.
Yes,
He has worked as district judge.
yes. Now,
Now another thing, interestingly, oh, here you see another thing. You see this is very interesting.
my lord,
AA is only as applicable for the state of Assam.
yes.
Okay.
Yes.
So therefore, here it is mentioned that he has for a period not less than 3 years been a district judge or an additional district judge. Now, to be a high court judge or a district judge, what is the qualification? Provided that a judge may by writing under the every person who shall be appointed a remand, judge may be removed. A person shall not be qualified at least 10 years of practice held as a judicial office in the territory of India. Now 217(2). So for a judicial officer, he has to have 10 years. So therefore, for the purpose of Assam, is that he is working as a district judge
Yes,
or an additional district judge
yes.
or as both for a period of not less than 3 years. So for that it is 3 years.
Yes.
But if he is otherwise a judicial officer holding post for 10 years, he can become also a labor court judge.
Yes. Yes.
But in doing so, he has to be, the consultation of the Assam High Court is required.
Yes.
Now, these consultations do not appear to be same to what it is given in 236 to 35, where the Supreme Court says another aspect. This consultation seems more like a deputation types, taking into
Yes.
consideration the rules of 2015 now,
Yes.
which makes it clear that the deputation would be for 3 years.
Therefore,
And the Guru Swami's judgment also say that the deputation which it goes has to be as per the terms and conditions between the lender department and the lending department.
yes. Now, so far as 7A is concerned, Lordship will find, my lord, only, my lord, in case of, my lord, 3A, he is or has been a judge of a high court. Only A is the only exception where a, my lord, sitting high court judge can become a, my lord, presiding officer.
Or has been.
Or has been, is that it is common for all other, my lord, subsequent provisions. Then Lordship will kindly see, my lord, double A. He has for a period. This is, my lord, past. He has. Then
He has. No, we don't go by double A. We go by the double A here. Our double A,
Yes.
not that double A. He has worked as a district judge
Yes.
or an additional district judge or both for a period of not less than 3 years.
Yes. So that means he
Now
has
here he has
yes.
for a period not less than 3 years been a district or a year. So he has. So a person who is working as a district judge can also become.
Yes.
And here the word he has worked as a district judge or year or has the qualification to become a high court judge.
Now B is interesting. B will throw some light, my lord. B says he is or has been a deputy chief labor commissioner central or joint commissioner of the state labor department, having a degree in law or at least 7 years experience in the labor department, including 3 years of experience. So emphasis is on the labor department. Then provided that no such deputy chief labor commissioner or joint labor commissioner shall be appointed unless he resign from the so-and-so state government as the case may be before being appointed as a presiding officer. So, my lord,
He has to resign.
yes, the
So this is permanent for him.
yes,
It's permanent for him.
yes.
For,
But so far as my lord
for
judicial.
a High Court judge also,
Yes,
he is,
he is.
has been a judge of the High Court.
Yes.
Now, if he is, he can still be there. And now see 215, because this is not amended, 2015
Yes,
rule says that he can be there till 65 years.
yes, yes. There is no quarrel to that.
And for a retired district judge who retires at the age of 60, he goes till 65.
Yes, he was still 65.
But if he is otherwise there, it is only for 3 years.
Here. So this is with regard to presiding officers. Nothing has been spelled out in 7A with regard to my lord the subordinate staff or the administrative setup, my lord. So that is left open to the government. So therefore, my lord, what had transpired at the time of creation of the post of register in the industrial tribunal, that material will be, my lord, because this is the broader issue which lordship has rightly spelled out, my lord. Because we can understand, my lord, that this is a promotional, CEO is a promotional post, his educational qualifications are different.
Mr. Das,
Requirements are
what
different.
worry is mine is not for that.
Yes,
My
yes,
worry is very
correct.
big.
Lordship is correct.
See, what happens the moment I pass this judgment,
Yes, it will have far-reaching.
may have a long
Yes,
effect
yes,
that if I say that, okay, he's out,
Yes.
one belongs to the labor department.
Yes, yes, yes.
Tomorrow the High Court can't do anything unless it is being set aside. My judgment is not set aside. You are not involved. You may not be involved then initially. Said, okay, why should we? He's there. He's asking for enhancement. He's not got it. Why should I bother? But that observation may affect the right of the High Court to exercise control over him. That is one. That is the only worry on which I am doing it. Otherwise, there is no problem. For him to be his case out there very well. They have categorically mentioned out here that, look here, this post we are creating in the year 1966, he is like an officer. He is appointed by the APSC. He is not, his post is a promotional post, not a promotional post. It is a direct recruitment. So he cannot be equated with the head assistant. The head assistant again comes under the ministerial cadre, but he is an officer.
Mode of recruitment is also.
Mode of recruitment, all these things are different for him. But therefore, to dismiss him on this, but the moment I do so, without going into all these things, that as regards creation of post and all, by this document, it's so.
So control is.
Only control is, but because the moment I say that it is the labor department, the labor presiding officer can't control him.
Regarding the disciplinary control, but even then I'll do some work and
No, disciplinary control, what is the doubt you have?
go back to 35. Renu. On the para 23 of Renu, all the subordinate codes are without the High Court has the supervisory control in is the ministerial staff as well as the other staff of the as per para 23 of Renu. So
But does it say anything about labor code?
say para 23.
The main problem is perusal of the act and the rules framed therein under makes it clear that the High Court has no business. High Court has no business. Now the recruitment which is being done,
Yes.
appointing this ministerial staff, is also not permissible. As per law, strictly looking into the act and the rules. Because source of power is where? Here.
The rule doesn't say anything about how the recruitment is to be made.
No, it says that the appropriate government will do it. So under no circumstances the High Court can appoint. Therefore I asked him, who is appointing this staff? No, High Court only does the selection. No, this is the appointment.
Appointment.
That is what I'm saying.
My lord, there
That
is,
is the problem which I'm saying.
my lord, there is another aspect, my lord. That is,
Again, confuse me more.
no, my lord, one creation of the post of head assistant is being formulated. There, the head assistant will draw a higher grade pay than me, my lord. I have annexed that at page 254 to 55.
Then give me that lever. That is also better. Not to go into all these things.
This is a proposal, my lord.
Proposal.
Page 254. This is addressed to the registrar vigilance. If my lord may come to after the table, that's the existing staff. My lord may come after that. From the above staffing pattern, it is evident that there is no scope of senior administrative assistant of this office for any promotion upgradation in future, and for creating promotional avenues of all staff, creation of the post of head assistant is utmost important. Since this court is headed by a senior most grade 1 judicial officer and the post of presiding officer is equivalent to the post of district and session judge, the registrar of this tribunal is a class 1 non-judicial officer with grade pay of rupees 12,700. Deals with all administrative matters. Therefore, the post of head assistant is required in this office to assist the registrar in all administrative matters with visit responsibilities. Financial implication of creation of head assistant for 1 year would be pay band 30,000 to 1,10,000 plus grade pay 13,900.
Has anything happened with this?
This is a proposal. This is only a proposal.
But he is like these people, our register administration. See the 67 rules. 67 rules as the register administration. Register general, register judicial, every post are there. The register judicial, register general, register vigilance, all these posts are from judicial officers. Register establishment is a non-judicial, but he's a register. On the other hand, the other posts which are down below, just for SHA and all, joint registers no. Joint register also is an official post, it's an officer post. Whereas down below, which are non-gazetted posts, they will come under the ministerial cadre, which is not there in the Assam district establishment rules. They don't have that concept there because this is just ministry. Am I wrong?
Please correct.
So here in the Gauhati High Court rules, 67 rules, you see them being created. Just for example, let us say, because you can't say the joint register to or assistant register to be in the post of ministerial. And more particularly, many of them are judicial officers also, if I'm not wrong. And who are the gazetted officers? Means how a officer is given the status of a gazetted officer?
I understand this, their appointment has to be published in the Gazette. That is why they are called Gazette.
Look, 3 documents of the writ petition may throw some light, my lord. Annexure 1, I'm reading it, my lord, page 30. My lord, how, my lord, the establishment of labor force and industrial tribunal. Page 30, lordship, kindly see, my lord.
Yes.
Subject creation of post of judge industrial tribunal under the industrial. The governor of Assam is pleased to sanction the creation of post of a judge for so and so under government notification 1957 without allowance also expenditure division. Now this is issued by the labor department. Then lordship will kindly come to page 37. That is his appointment, the petitioner's appointment. Page 37. Page 37. On recommendation of APSC, the governor of Assam is pleased to appoint Dilip Kumar Devasama, that is the petitioner, temporarily to officiate as register so and so, as admissible under the rules with effect from so and so, posted industrial.
Under the rules means?
As admissible under the rules. Lord, that is, my lord, incorporated in the ROP. Because this speaks of the pay structure. So naturally, my
Under
lord,
the rules.
ROP. Now, my lord, what I am trying to draw an inference, my lord, this appointment is also being made, my lord, by the Labor Department.
Deputy Secretary.
Yes. Now, Lordship will kindly see, my lord, page 41, Annexure 5. But clarification regarding Labor Court Assam, I am directed to refer to your letter, my lord, so and so, and say that the Labor Court is preferring judicial function as a court. The Labor Courts have been held to be as a subject to the High Court's power of superintendence, Article 227 of the Constitution. The Labor Court judges can be held to belong to the judicial service. As such, circular so and so will be applicable. So these are with regard to, my lord, the presiding officer. Now, this communication is also issued, my lord.
So
by
now
the-
this is being done by the judicial.
Yes, yes. So therefore, in our affidavit.
So therefore, by this document of 2006,
Yes.
the government have put him
No, government.
put the presiding officer.
Yes, presiding officer.
They are part of the judicial service too. Some judicial service.
Tomorrow, tell me, there is no presiding officer, High Court judge is appointed. He will be under the AGS. No, I'm telling you, how do you take care of it then? Can the High Court have control over that?
Control over the judicial.
Let us say that, no, over the labor code. You are having a control because the judicial officer happens to be a district judge or so and so. Let us take the example, a High Court judge becomes tomorrow. You are 65.
Yes.
I retire tomorrow and take up that. Then, can the High Court says, okay, I have a control over you? How? A control under 227 is different. You see, control over 227 is different. But a control under 235 is different.
Exactly to my lord's query, my lord, the department has also queried, and that is specifically spelled out in my affidavit. Lordship may kindly come to page 123 of my affidavit, Finance Department affidavit, my lord, paragraph 8. Kindly see, my lord. So answering the following respectful back to submit recommendations made by the Honorable High Court Committee were duly examined by the department, and in the light of it, clarification was specially sought for as to whether the industrial tribunals or labor court comes under the term subordinate judiciary as defined in Articles 233 to 237 of the Constitution of India, which relates to subordinate judiciary. Further, in view of the integrated structure of judiciary across the country, and the fact that the City Commission's recommendations have been adopted uniformly for the subordinate courts in other states, a request for comparative information was made regarding the pre-revised and revised pay scales of the posts of registered so and so in the states of Odisha, Bihar, West Bengal, which has not been furnished by the Judicial Department. It is stated respectfully that any proposal for enhancement of grade pay of state government employees necessarily entails significant financial implications. Therefore, such proposals are required to undergo scrutiny from all relevant perspectives, including constitutional, administrative, and financial perspectives before a considered decision can be taken. Now, this query was also made by the Finance Department.
But why are you asking the Odisha, Bihar, and West Bengal, not Delhi? Huh?
Finance, my lord, there.
Mr. Why is he asking not Delhi, Haryana, Chandigarh? You have been asking them.
Odisha, Bihar.
He knows West Bengal is best to ask.
My lord, these are, my lord, geographically maybe nearer, my lord. I do not cannot comment, my lord. And my lord, further in my affidavit, lordship will kindly see, my lord. My lord, paragraph 10, my lord, page 124. I am reading it, my lord. makes the state that due to non-receipt of specific information sought in relation to the status and pay structure of Register of Industrial Tribunals and Labor Courts in other states, the Finance Department advised that the proposal for parity be placed before the Pay Commission. The Pay Commission, being the appropriate expert body, is entrusted with the responsibility of examining and rationalizing inter-cadre and interdepartmental pay structure, and therefore it was considered that it is for the competent authority to opine on such matters of equivalence and parity. Then thereafter, my lord, the next page, paragraph 12, my lord, in subpara 3 is stated, my lord, further so and so, the pay scale of stenographer grade 1 of the Industrial Tribunal Labor Court has consistently remained higher than that of the registered industrial tribunals and labor courts.
Para?
My lord, page 125.
Where
Paragraph
is it?
12, my lord, down below, last but second paragraph, my lord. Further, the petitioner's own comparative data reveals that the pay scale of stenographer grade 1 of the Industrial Tribunal Labor Court has consistently remained higher than that of the registered industrial tribunals and labor courts. So there is a, my lord, historical background, but of course, my lord, with regard to other posts. Now, it is respectfully stated that if there is any discrepancy in the service structure or pay parity, the concerned administrative department shall have to submit a duly justified proposal to the finance department. Such a proposal must be accompanied by all relevant details, including the
Mr. Nair, taking into account the 66th point creation of post, can you submit out here with something whereby the stenographer's post has been given a higher pay? If that is also, that can also be done without going into decision. If that is being comparative, then it is means a person who is otherwise treated as an officer is given less than the other post of staff. Something to the effect, if you can develop your arguments on.
As of now, my lord,
Because you see the comparative with the head assistant becomes a bit dicey, or it becomes difficult for you. But taking into account there are various parameters by which it becomes very difficult for this court to override the Bihar judgment. But be that as it may, if we can look into in this angle, by which it cannot be below the, because see the creation of the post is 66 as an officer. And therefore the post of the, maybe they are doing it. They are doing it, that doesn't mean that if they are doing it, show me the year of, you can get it out there in industrial, because they are referring to those industrial tribunals in the other state. If you can come up with some materials to the effect to show that there are, those have been given a higher, the register is given higher, may not be the scale, but the higher than that of the stenographer grade 1.
I'll try that.
That is a line we can do it.
I'll try that. And
I want to give it to you, but the fact is, here I'm having that problem.
I understand.
I'm sorry, my
And Mr. Rajiv Barbudari is fighting tooth and nail not to give it.
No. I'm only going by my affidavit.
One aspect, sorry.
Well, it may help, my lord. Well, page 127 of my affidavit. My lord, that's, I'm sorry, my lord, I have missed that paragraph, my lord. That administrative control which lordship was harping upon, my lord. However, despite such reclassification, the post of Register Industrial Tribunal Labor Court does not find mention in either of these notifications. Instead, the said post continues to remain under the administrative control of the Labor and Welfare Department. And as is also evident from its placement under the head of Labor and Welfare Department in the Assam Service ROP rules. Now, my lord, lordship will kindly see, my lord, page 139 of that affidavit. Page 139, Annexure E. Now, this is the notification issued by, my lord, the Judicial Department. But it says, my lord, in pursuance of cabinet decision dated so the Gauhati High Court, so the Governor of Assam, he is pleased to redesignate the following 12 numbers of posts of the staff of subordinate judiciary so and the redesignated post shall carry the same pay scale as are attached to the original post. Here lordship will find, my lord, that the Seristadar, he becomes, my lord, the senior administrative officer, my lord. And the superintendent family court, my lord, chief administrative officer.
Why is this relevant?
My lord.
Why is this relevant?
Look, this is relevant because of the, my lord, the nomenclature has been changed, my lord. Because that, see, otherwise, earlier it was, my lord, the Serastadar. Serastadar in the district judge's court is the highest ministerial officer in a subordinate judiciary within the district. Now, the designation of Seristadar in the district judge's court has been renamed as, my lord, the chief administrative officer. So he is the head of the entire ministerial setup in the district judiciary.
Now, Mr. Nair, see one thing, our 1967 rules. Scale of pay of the stenographer grade 1 is 30,000 to 1,10,000 with grade pay of 13,300. And that of the extent register is grade pay with 14,500, which is same with the senior private secretary. This is for the extent register. Then, what was the scale of pay then for the register corresponding to the senior stenographer grade?
My lord, stenographer was less, my lord. If
Much
my lord-
less. So therefore, what is being done out here? Here, therefore, I was referring to register post is not there in this establishment. Let us not go into that arena. Let us see where you have a register post. And therefore, you see register post for the stenographer.
my lord,
Now, the stenographer cannot get more than that of the register.
my lord.
So if we can develop out there, because you see the 67 rules says about the register.
Yes.
Take out everywhere because it cannot be less than that.
Yes.
It has to be more than that.
My lord, in fact, even in the district judiciary, if my lord comes to page 20 of my writ petition, the comparative table which I have drawn up. This was there even in the district judiciary. My lord sees the table at page 20. In 1996, the scale of the registrar and the Sirisadar were the same at 1,785 to 3,007. In 1998, they were also the same, 4,300 to 9,075. But in 1998, the stenographer grade 1, even in the district judiciary,
They have been given the benefit of the city commission.
that was from 1st of April 2003. But my lord, the Seristadar's salary, the grade pay is higher than that of the stenographer grade 1 in the district judiciary. Here, my lord, prior to 1st of April 2003, the stenographer in district judiciary was drawing a higher pay scale than that of the Seristadar. But this, from 2003, my lord, that has been taken care of.
No, you see, do industrial tribunal, labor court, or any other place where the register gets less, because you see the formation, the post, how it is being created in 66. They have been created as a staff.
My lord, my lord.
Whereas the post of the register is created as an officer.
As an officer. My lord.
He is a non-judicial officer.
My lord.
Pay was high in 66 at the time of creation of post also.
Yes.
The pay of the register was higher.
Higher than that of the stenographer at page 32.
That is what now.
In 75 to
575. Stenographer.
Stenographer was 140.
But in between, my lord, it has gone up.
So therefore, you see here the register is 375 to 436 to 575. Whereas here it is 140 to 225.
Yes, my lord.
So you develop your own this You cannot give less than that.
Yes, in fact, that is one of my pleadings there.
I think we could go by that. Because it becomes difficult for you to do it with the head assistant. But you have a pleading now. One line is enough. Oh, fantastic.
I have it, my lord.
And they have also replied. So we now, I think this is the best way. to submit it.
Reply, my lord, if I may read it, my lord, part of my lord paragraph.
Don't. Yeah, that is enough, Mr. Yeah, how much torture are you going to do to the petitioner? I think you see,
No, because.
you see, no, Mr. Professor, you have to understand. Goes to the register any day. If you go to the the DRT or any other, DRT also have a register now. The senior stenographers out here earlier used to go to become the register of DRT because they had a higher scale of pay at that point of time.
Because the difficulty perhaps has arisen because of the fact, my lord, that this is a direct entry post and stenographers, all this that they are, my lord.
No, stenographer is not that. There is only one stenographer.
Maybe, but he has the promotional avenue.
No, there is no promotional avenue also there in the register. There also there is no promotional avenue. And promotional avenue to where? Stenographer grade 1 can go where? He either would he take up register with his scale is pay is less, or he may have to go to become the presiding officer, which 7A does not permit. Then where will he go? Unless he is being transferred out here to Gauhati High Court by the grace of Mr. H.K. Das. Otherwise,
What is?
I think this is the way out.
Page 21, my lord.
I think this is the way out. Let us not go into those.
Page 21 at the top of the page, just
Yeah.
below the table. From the above, it is crystal clear that the pay scale of petitioner as registrar industrial tribunal is lower than not only that of registrar of district and session judges establishment, but is also lower than that of the stenographer grade 1 in his own establishment. Thereafter, my lord, para 25. Non-judicial staff of the establishment of industrial tribunal labor courts of Assam, other than that registrars, are getting the benefit of shifting away. It's only the registrar.
Or Mr. Naik, can we do it in this manner? I'm thinking aloud. We equate the post in the ranking of the register with the registrar and give him the benefit of the SETI commissions. And then say that in view of that, his post is higher than that of the stenographer. And his post, he cannot get a salary less than that.
Yes, ma'am.
And then put it to the pay commission.
That is the most, my lord, that will be the rational, my lord. But one pair.
We don't say that he should get, I don't say that he is the equal pay with equal work as regards him with the head register. But taking into account the functions he does, his post cannot, he renders similar functions like head assistant. So, and the head assistant post would be higher than the stenographer's. Or the head solicitor would be higher than the stenographer, and therefore he cannot get, and this aspect is taken care of by the pay commission or the finance, and thereupon give him.
That would be
And should not be less than that of the stenographer.
Minor.
Because what is happening, Mr. Babu, one has to understand one thing. Because of the fact that the word register is not there in the SETI commission, petitioner is not being given the benefit.
Yes, ma'am.
Yes.
They have said so, my lord.
The document for the benefit of the petitioner is the notification dated 37/2012.
Yes.
My understanding. Lordship need not go anywhere. If this notification is relied by
The finance.
his first argument.
Where is that?
On page 77. This applies
It's
to.
not required to go anywhere.
Yes, where?
Page 77 is the notification, wherein the petition has also been paid. Although the grade and status that rider is there.
Where?
page 79.
Below the, sorry, please.
Because this is the best handle he has got for it. Clean.
corresponding grade and status working in the various courts like MSCT, so and so, so and so, so and so, which falls again. No, it is okay, but how do I put him with that of the sister? Give me that handle. You see, the handle has to be like this. He is being deprived because his name, the register is not, the name does not function, appear out there
Yes, that is
in the city commission. Whereas all others, even the stenographer's name is being given out there in the city commission, so there he's getting the benefit. Whereas the stenographer's post all along at the time of the creation was below to that of the register in the scale of pay. So under such circumstances, stenographers cannot get merely because of the city commission, the register's post cannot be below that, the scale of pay. And as such, directing the finance to look into it and give him equal to not less than that of the stenographer. It can go beyond the stenographer, but not less than the stenographer. I think that seems to be more logical.
Because, my lord, what finance have understand, the sum and substance, my lord, of my affidavit is that, my lord, he is claiming, my lord, the pay scale which exceeds, my lord, the highest of the pay band for direct entry-level posting. This is what my sum and substance.
No, now, as of now, the stenographer out there in industrial tribunal is getting more than that. Him. So his scale has to be either equated or above, but not below.
Yes.
I think that is the only way.
Because that will be, my lord, comparison intra, not inter. Because if we go.
But then the finance would have no problem.
Yes.
If that is being given.
Because if you go for, my lord, my lord, establishment comparisons.
Then it becomes very difficult. Now, if we go with the head system, it becomes very difficult.
Because of the other judgments I understand.
If
The
we confine
other judgments which have been relied on by my friend.
Which one?
Bihar and the others. Bihar service.
Why Bihar? No, Bihar would not. Bihar would not come in because you see the creation of the post is the most important document.
Yes,
With the creation of the post, you were higher.
yes,
Now, because of the city commission being applied to everything,
I was right.
and all other persons have got it because of the fact that your name does not feature in the register, and you are therefore being deprived.
Yes.
So we therefore tweak it that he should also be there. It cannot be less than that, and he cannot be deprived because of that. I think that is the best way.
There is an intra within the establishment.
Within the
establishment, if yes, but then perhaps.
Your Lordship, this proposition will find support from page 32. The creation of the post. This proposal.
And
The other aspect and observation, if
so we can close the hearing today and reserve it. I think this is the best way.
This has become a case wherein juniors are getting more pay and I am heartburned.
Ah.
Raise that.
I thought your junior was getting more.
One aspect which, one observation if Lordship deems fit, my lord, that prior to 1st of April 2003, the scales of registrar and solicitor were the same. If that.
Mr. Nair, I will think about it as regards whether to equate with the head registrar or not. The best option would be
leave it to
have it with the creation of the post.
Yes.
And the deprivation to you because city commission did not include that aspect where and thereby you are now being deprived to get a scale less than that of the Syria because of that being not applied, which therefore not only affects your right to get more, but also affects your dignity, the status of the post, for which it cannot be less than this, and right to live with dignity also 21.
They have admitted in page 100.
And therefore make it have to be, you see, finance also has to be given some handle. Finance has to be said, okay, you give him not anything below, what do you call,
Stenographer.
the stenographer grade one. And thereupon, and you see, when you are creating that post, the next post also, there's a request. You have to also think that he's the registrar.
Absolutely, my lord, because
Because it cannot be, the head assistant cannot get more than that.
therefore, my lord, when the proposals
Luckily,
are
you have
made
not
to-
done it till now.
No, my lord, when the proposals are
Hearing
made to
completed,
implement
judgment
it,
is up.
all the permutations and combinations are being done, but 7 except this particular case, this particular post of my lord, the Register of Industrial Tribunal. That is why also my affidavit also spells out. Because nothing was forthcoming either from the Labor Department or for that matter, my lord, from the judicial. We had asked for all the data. We were there.
Because entering into that fold, what the head assistant will have a lots and lots of complications, which someday sitting in division bench would be better to decide.
No. It will be a Herculean task, my lord, if he makes an endeavor to make a comparison inter-establishment.
It becomes very difficult. No, not only, why should I go into that establishment? That, so therefore, the way out is creation of post. Next comes 37, by which the city commission has been accepted by the state. 37, 2012, and thereby saying that only he has been given the benefit, he has not been given benefit, which was a post higher in rank and scale of pay. So he cannot get below that at this.
And
This
page
is-
110 of the.
This would be a much simpler exercise. What do you say, Mr. Das?
Yes,
Much
that is
simpler,
the
no?
bottom line, my lord.
And Mr. Nair's toil to fight this litigation is also to be appreciated.
Yes. That will be
Yes,
the
given the space.
Yes, even and those documents which we have included. And in fact, that 66 clean state thing, the 66 document, and not to go into those aspects because it has a lot of. My only worry was the moment I say that it cannot be equated and all, he belongs to the labor department, it will have far-reaching consequences. You didn't say that. You never argued this point. None of you ever argued this. I only saw it one paragraph was there in his affidavit. The moment I saw that, I think we can.
my duty to spell out everything.
From his affidavit, I got that idea.
Otherwise, at the end of the day, a junior cadre post drawing more money and senior cadre person he is drawing less money. That is the, my lord, one and simple reasoning, my lord.
I think that is enough for that.
Yes.
And being
Chalo.
left out because of the not being included in the Shetty Commission.
Yeah, that is
in-
what I'm saying.
Man, that is there.
The
in page
benefit of
110.
the Seti Commission has,
Yes.
whatever, everybody has got a benefit. You being a part of the judiciary, you are a part of the judiciary has to be mentioned.
Right.
Being a part of the judiciary where courts are functioning judicial, where these tribunals are functioning judicial functions. You have to be also be getting this benefit of the Seti Commission.
Right.
And therefore, otherwise, it would have, yeah. Therefore, my idea, I got it from here also. Now, here, you don't have a post of registrar.
Right.
Because Seti Commission was only looking at qua the subordinate court jurisdiction,
Yes, subordinate. one.
not the High Court.
Right.
So when they were looking into there, they were doing it. But the High Court also was done, na?
High Court's
They
observation
went
in
into,
the
they
second
actually.
All India Journals.
Ah.
But the Shetty Commission mentions about registrar in other states. Other states, I have annexed that. Registrar or Sadar by whatever name called, the different nomenclatures.
They do it.
They have that. I have annexed that.
No, it's okay. So therefore, that document, you just put a note on somewhere. Anyways, Mr. Nair, don't trouble me to open the file, that voluminous file. So you just put a note on that aspect, where is that aspect. So, and just give it to him. So that register, if it is given out there, but here so therefore he has to, Seti Commission benefit has to be given. I know, just one that the moment the Seti Commission benefit is given, you or would be, if not equated with the stenographer grade 1, it would be more than that.
perhaps that might be the reason why the finance department has sought for comprehensive data from the other states. City commission benefits had flown to those states, Orissa, West Bengal, Bihar.
They've flown.
Yes, they've flown. It is the,
Anyways, I will do my own homework. You just give that.
Now,
note.
if that argument is now newly developed, perhaps I will be left with no, anti-deterrent arsenals, maybe on the next occasion, I don't know.
No, therefore, I think giving him something would be better.
Yes, yes, yes.
Hearing complete judgment. Won't you? No, they're lying, they can't help it. You fix another thing. Mr. Gupta,
I'm sorry.
matter could not be taken up because the council was not present through the video conferencing link.
Can be taken up.
When?
Hold on the.
So many matters. Huh?
Fifth of.
Fifth, I have already 20 matters. But anyways, fifth, let's see. আমার ইয়াত আজিকালি ওলাই নেকি কোনকেইটা matter আছে?
Any date except fifth.
কি matter আছে ওলাই নেকি? Fifth কোনকেইটা matter আছে ওলাব নেকি? বুজি পোৱা নাই। Fifth কি matter আছে ওলাই নেকি লিষ্টখন? ইয়াত নোলাই তো।
Any date except fifth,
নোলাই। এইটো আইন দিবচোন তেতিয়াহ'লে হা? তেতিয়াহ'লে তাত কেইটা পাৰ্ট আছে চাবচোন। Because if I fix it on fifth, again the problem is because you see 2 days holidays again.
Yes, Lord.
My lord, in 10th, my lord, hearing day after 5th, my lord,
10th or 12th, Lordship.
10th.
Can you agree for 7th? But 7 I have already 83, but it is one series. Because I'll dispose it of in the court, my lord, that order. If you are agreeable for that. 7th.
No problem, but senior counsel is appearing.
You have a bad case after his affidavit. Because that is why I asked him to put it on
Lordship,
affidavit.
Lordship,
Once the
fix-
affidavit is filed, then they will.
Lordship may fix on 12th, Lordship, as a first item.
7th would be good.
As a first item.
My lord,
Seven.
we will have the time to dispose it of, my lord. Otherwise, again on 12th, my lord, if
12th as a first item, Lordship.
12th.
Yes.
12th.
As the first time.
First item,
At the
my
top of the list.
Hello.
12th. thought. 12th. I don't think it is there.
My lord.
Yes, Mr. Tiwari, you're waiting till 5 o'clock. A busy council, otherwise everywhere.
I was told that my lord normally sits very late. So then I had to stay over here.
No, I have been I have been made to sit.
I was given a very, very, alarming picture of the court. So then I decided nothing doing, then I won't take chances. I'll remain over here.
Okay, what was the matter about?
Matter my lord, it's Assam Land Revenue Regulation, Chapter 10 is involved. The land of a tribal occupied by a non-tribal, that is the whole case. It is the second round of litigation.
They are not doing anything.
My lord, it was part heard for a long time, then it was.
Before me?
No, not before a launch, but before another bench. Then again released because it could not be concluded. So that's why.
Which year matter?
2015.
15?
2015.
Okay. When do you want it?
Because next week I'll go to outlying bench. If it could be on 9th or 10th.
9th or 10th. 10th of top of the list, sorry. 10th, top of the list.